on three bases. The first basis is Section 12, is a self-contained section that gives you access for the minister to consider matters such as specialty, double criminality, minimum gravity, and the issue of extraditable offense. So therefore, you have a right preliminarily at that point in time. So therefore, you are entitled under the law by virtue of the other sections to have that issue determined at first, because if it is that the minister who is biased takes that decision to issue the ADP, what follows upon that is a number of other processes which would not vindicate your entitlement under Section 12 to have that issue determined early. I'll give you an example. If you have, let's say something doesn't satisfy a requirement of minimum gravity, it is for 2 years and less, or it doesn't satisfy the issue of being an extraditable offense. For example, if you are being extradited for a crime that does not satisfy the requirements of double criminality, the accused should not have to defer the redress to a later stage, but the accused should be entitled to have the ADP not issued and to access the rights under Section 12. In other words, the fact that there are other relief down the line which may or may not be triggered does not mean to say that you should not have that facility open to you, because it could very well be that the minister cannot issue the ATP because of some requirement not being satisfied, and therefore you would not have to go through the hardship, the expense.
All right, so Mr. Hussain, just to summarize this, so is it then that your position is in a rule of law regime where procedural fairness is a value, that the entitlement to take a point that could be to your benefit at the first opportunity is part of the protections afforded to you?
Yes, my lord. And
right.
therefore fearless. Sorry?
Counsel, help me here. The matters that you mentioned, the things which, as it were, the minister is required to tick off, is there in this case any assertion that the minister let through the application when there were things which an unbiased minister would have adverted to and would not have allowed or would have given deeper scrutiny to or anything? In other words, your allegation of bias, is there anything in relation to which you can point that it operates, or do you say simply bias as a general proposition? I just want to get clear the distinction, if any.
I'm glad you asked that question, Lord, because this is not a case about. This is not a case about proportionality. It is not a case about rationality. It is a case about standing. So many times a minister may take may take a right decision, but because of the fact that the decision is impugned by bias, the varies of the decision or the proportionality of the decision, the rationality of the decision does not matter. For example, in the case of Bovis, which is cited by the authorities. In Bovis, the one person in the tribunal had a predisposition to take a decision. The entire inquiry was set aside because bias goes to the heart and the soul of the decision-making process and confidence in the administration of law. It is not only the individual rights have been vindicated, it's the public rights that have been vindicated. And therefore, to answer your question,
I hope you'll do us the kindness of accepting that we would have read thoroughly all the expositions on bias. Yeah? And therefore, all I'm trying to do is to get you to deal with the particular point that there is in relation to the things which the minister should have checked and upon which the minister should have satisfied herself, that there is not any particular aspect where you can say, in relation to that, see where the bias operated. It is, as I'm trying to get clear, a general hint that this was a decision being made by a biased minister. Am I correct?
The consequence of the bias does not matter.
Councillor, I'm not asking about the consequence of the bias. I'm asking about the way in which it operated.
But we are not in a position to say, Millard.
Thank you. You have answered my question. Thanks.
And if I may just add,
Mr. Hussein, Arif Volkan here. If I could just follow up though, because when you were answering my brother Peter Jamadar's question, you started off by saying that there were three things that you would say in terms of whether these allegations can be taken at a later stage. What I'm interested in, you talked about, and this ties in with the previous question, the number of things that can be asked, that are relevant, that the minister is required to do at this stage. And you listed a number of things. I'm particularly interested in the scope of Section 12.2, which of course speaks to lawfulness or unlawfulness. And so in terms of what the minister is required to do, would that not include as well Section 8.1? And 8.1 sets out 8.1a, whether the offenses of a political character, 8.1b, whether this is a sham punishing someone for their nationality, religion, or political opinions, and C. So does that also fall within 12.2?
yes, well, respectfully, because if you look at 12.1, 12.1 is quoted in mandatory terms, but 12.2 is quoted in permissive terms, but 12.2 is quoted in mandatory terms. And 12.2 requires the minister not only to have consideration of the contents of the acts, but to have the consideration of the law as a whole. And therefore, my lord is quite correct. So therefore, if it is that there's a political issue, if it is that there is an issue with respect to double criminality, that is that the offense is not an offense which is triable in Guyana and in the United States, if it is that it is under 2 years imprisonment, if it is that it doesn't satisfy the requirement of specialty. In other words, when the person goes abroad, he's not extradited to a third country unless the minister's approval is there. So all of these things have to be looked at by the minister. I'm not saying the minister has to do a judicial review as a court, but the minister must assess the various provisions of the Act, which we have identified, sections 5, 7, 8, 9, 11, 12, and 17, and to see whether on an examination of that, not necessarily judicial, but on an examination of that, those things are satisfied before the ATP is issued. Now, the ATP is issued in a form, but before that form is filled out, that is Form 1, the minister has to satisfy herself in respect of those matters and may seek further and additional information from the requesting state. So
I think we follow you on that point very clearly, Council. I want to go back to the beginning, because I think we started off on the question of what is required for the issuance of the ATP. And the question is whether the observance of procedural fairness. Sorry, do I have your attention, Council?
Yes, my lord, sorry.
Thank you very much. The question then was whether the observance of procedural fairness is adequate in the sense that the decision maker, i.e. the minister, had an open mind and exercised the functions genuinely. Now, I understand that your opponents accept that as being a standard that is applicable, but you want to go beyond that. And I'm trying to understand, in light of all the questions raised, how far beyond that you'd like to go. You would admit that the extradition process involves various stages. There is the preliminary stage, including the ATP process. There is the judicial stage, and then there is the surrender stage. Are you saying that the same standard applies in respect of each of those three stages?
Normally, no, that it's very different tests that have to be applied at different occasions.
Wonderful. So my brother Justice, I think Jamadar asked you whether the matters that you are concerned about could not be ventilated and adjudicated at the judicial stage. At the stage where the ATP is granted, that is the preliminary stage, I think you would agree. So
Yes,
the question then is, can these matters that are of concern to you not be adjudicated at the judicial stage?
Respectfully, no, Millard, because of two reasons. The first reason is that is an entitlement that the accused has under the Act. As the first.
What is the entitlement to which you refer?
The entitlement to have a Section 12 consideration of an ATP.
In an impartial manner.
In an impartial manner, in an unbiased manner.
Well, that is what the other side is agreeing, that when the minister approaches the question of the grant of the authority to proceed, the minister must exercise the functions genuinely and with an open mind. What is wrong with that standard?
But because that is a standard of a clear mind, is a standard that is applicable in situations where there's policy, there is a political mandate, persons have been elected with a policy position to.
Council, I understand that because I think you said that before, but what I'm asking you is if that standard is observed, it's almost a gatekeeping function, you could say. It then goes to the judicial stage. Why can't all of the concerns that you have not be properly ventilated at the judicial stage? Because there you have a judge who is presumed to know the law and who will therefore be able to see whether Section 8 has been satisfied. In fact, I believe the FOA requires that the magistrate, the minister, the High Court, Court of Appeal must be satisfied that Section 8 has been complied with. So what I'm asking is why, and I think my brother Justice Ibu Osuji may have been getting at this as well, why are we not prepared to allow the judicial process to sort out whether the conditions necessary for the compliance with the request for extradition have been fulfilled?
Because of the fact that the other processes are processes which the Act says the minister or the High Court, as the case may be, or the magistrate, all have concurrent adjudicative processes at different levels.
I understand you. So what if the minister gets it wrong?
Well, if the minister gets it wrong, well, first of all, if the minister gets it wrong on the point of bias, in other words, if the minister is biased and found to be biased, not on the basis of an open mind, but on the basis of apparent bias or presumed bias, the cases demonstrate, or because the
What I'm asking you, Counsel, sorry to interrupt, but if the minister gets it wrong, is that error not correctable by the court?
On a judicial review, on the basis of taking a decision under Section 12, which was wrong, and FROOM establishes that point.
No, I'm sorry, I'm not hearing a response to my question. I'm asking you, if the minister gets it wrong, in whatever regard, is that error not correctable by the court?
The magistrate cannot deal with the issue of bias. The magistrate cannot deal with the issue of abuse of process. The magistrate cannot deal with any of those things, Millard. So the High Court.
Why not?
Because it has a statutory jurisdiction.
Right, and the statutory duty has not been complied with. So why can't the magistrate correct that error?
Because of the fact that the magistrate is confined to an issue of committal. The magistrate cannot have a jurisdiction if it is that the referral to the magistrate is vitiated by bias of one kind or the other. So that is not for the magistrate. The magistrate is for committal, and the magistrate is now to apply a judicial test in respect of the issue of double criminality and the rest of it.
Well, I thought that the magistrate ought to have regard to whether Section 8 has been satisfied. And certainly, if we were to progress, just one second, if we were to progress the process for the extradition, and if we got to the stage of habeas corpus, then the court can have regard to anything and everything. I thought there was a very open-ended provision there, which allows for judicial scrutiny of the entire process. Bias, on due process, the court can have regard to any of these matters. Am I not right? Am I wrong there, Counsel?
If you look at 12, on the receipt of request under Section 9, the minister may issue a Form E, which is the authority to proceed, signifying to the magistrate that the request for the extradition of the person mentioned in the order has been received, and requiring the magistrate to proceed with the case in accordance with the provisions of the Act. So the magistrate has a peculiar adjudicative function based on the fact that the minister has perused the documents, has assessed the documents, and is satisfied that all the matters in respect of what is mentioned in 2, that is the question of double criminality, specialty, and all of that, has been satisfied. It is not the magistrate's job to deal with the issue of bias. Now, if you look at the case of Fuller, Millard, Fuller is a constitutional law case, and I've
So
cited
before you go to Fuller, whose job is it to look at the issue of bias?
It's Judicial Review Court. It's a judicial review court, or constitutional court that is reviewing the exercise by the minister of the Section 12.
So for example, just to be clear, so in habeas corpus proceedings, that issue is not litigable.
Let's put it this way, Millard. If you are incarcerated, you are committed, you are incarcerated, and therefore you have to wait until a habeas application comes up to have those matters considered. Whereas the courts, the parliament, has given you a right, respectfully, Millard, under Section 12, to have all of those matters reviewed and assessed by the minister before. For example, let's take an example, Millard. Suppose, for example, someone is referred by an authority to proceed, is issued by someone on defiance of minimum gravity, on defiance of specialty, and you are incarcerated. You have to wait until a habeas corpus application. The court says no. Right? Froome is an example of that.
Paragraph 59.
And paragraph 59 of Froome says very clearly what it is that a court has to do in respect of the issuance of an ATP, which is challenged on the basis of bias. If I may read paragraph 59 for you, which is contained in 22 of our submissions. It says that if it is administered acted arbitrarily, in bad faith, motivated by improper motive, or motivated by irrelevant considerations, Parliament could not have intended that a decision would not be reviewable. If that were the intent, it would violate the rule of law, right? Further, at paragraph 59, the court declared that if a minister's decision was impugnable on these grounds, then the individual's liberties, restricted judicial review, would be immediately available, because it was fundamentally unjust to insist that the individual complete each distinct stage of the extradition process in order to challenge the minister. This is right. So therefore, Section 12, as it is, stands as an independent statutory right, one of the 3 or 4 tiers of protection built in respect of an accused, and you have an entitlement, a statutory entitlement to have procedural fairness there. And to support that point, my lord, in Jaiwanti, the court could have said, well, look, it doesn't matter if it is that this particular inquiry was infected by bias. You can get your redress when the matter is being heard, or when you
See, Counsel, I take your point, by the way, that one ought not to have to wait until, assuming one got there, the habeas corpus proceedings. Section 17 does speak in very broad terms, by the way, as to what could be challenged in those proceedings. Accusation was not made in good faith or in the interest of justice. Any other sufficient cause. So there are very broad terms on which there could be a challenge at that point. But I do understand you, and I take your point that the person against whom the request was made for extradition ought not to have to wait until that stage. But you see, that is where the question of my brother Justice Barrow comes in, because he asked you quite clearly, is there anything that you are objecting to in terms of what the minister decided? Put aside the issue of bias for a moment. Is there any box that she did not tick, or anything that she did not consider? Was there any of the conditions precedent to the award of the ATP that was not properly dealt with? And I'm not sure I got a precise response from you. I think you sort of left that hanging and went back to bias. But could we just get a clear from you? Was there anything in substance about the minister's decision, aside from the issue of bias, that you take issue with?
Well, the point is, I don't know, because of the fact that we don't have access to what the minister took into consideration, and we say that because of bias, she might not have taken into consideration other matters, which is a matter which will be dealt with the habeas stage. But let me give my lordship an example of what.
No. Before you move on, so you're saying then the answer is no. You can't point to anything specifically which the minister did unlawfully, aside from the bias argument. Do I understand you correctly?
Yes, my lord.
Okay.
But bias infects her entire decision-making process.
Well, that is where we have the problem. At the beginning, the question is, well, what is the standard? Is it bias in the sense that you are articulating it, or is it a failure to observe procedural fairness?
And President, if I may follow up on what you've. No, I just wanted to.
My sister wishes to ask you a question, please. Yes.
I just wanted to follow up on a related point based on what the president asked in terms of the standard of bias. There's agreement that there is need for respect for procedural fairness throughout the process, including at this stage. But I think to kind of follow up on President's question about what that standard is, I just wanted to return quickly to the characterization of the statutory context and the nature of the function being carried out by the minister in the applicant's submissions. The applicant has submitted, and please correct me if I'm wrong, that the function being carried out or the stage in question is an adjudicative stage. I'm referring specifically to paragraph 16 of the applicant submissions. So if you could first confirm if you have characterized the function of the minister or the stage involving the ATP as adjudicative.
Yes, my lord. Yes, my lady, I say adjudicative because, and it does not matter whether it's adjudicative or non-adjudicative. The fact is what we say is adjudicative, and it's adjudicative of because of the statutory remit which I have identified in the submissions, which the minister is supposed to take into consideration. But even if it is non-adjudicative, as in Jaiwanti, You see, adjudicative does not mean to say it has to be a list inter partes, right? It does not have to mean to be a list inter partes. In fact, in fact, you can have an adjudicative stage where you are held absolutely in private amongst the persons. A good case for that is the case of Coupland, and is the case of
And Delaglio.
and Delaglio. In Delaglio, for example, there was an inquest where there was no party involved. And the learning on Delaglio, if I may just read it, very briefly to you, milady. It says this in Delaglio. It's in my speaking note, which I unfortunately can't forward to the court. But in Delaglio, what happened is there was an inquest, so there was no arrest inter parties, list inter parties between the various parties. And the court held, notwithstanding that fact, can I give you?
Counsel, you see, what I'm trying to get at is, I take your point that it's not really about whether the process is inter partes. What I'm trying to understand is how have you characterized the nature of the function that the minister carries out? Is the minister making any binding legal determination on anything at this stage?
No, milady, she's not making a binding legal decision, but she's mandated by the statute to impact on rights which go to the freedom of the individual, and at that stage to allow the person to go free and not issue the ATP if it is that the considerations which is required to conform to have not been complied with. For example, minimum gravity and all of it.
So counsel, you're speaking to the minimum conditions that must be complied with. And I see that you focused a lot on section 12.2. I just want to be clear on something. Do you read section 12 as requiring a minister in all cases to make a positive determination that extradition can lawfully be made? Is that what the minister in all cases is required to do?
Yes, milady, can lawfully be made that.
So you're saying that you read section 12 as requiring the minister in all cases to make a positive determination that an extradition can lawfully be made?
Yes, milady, and she is at the administrative stage, she is at the adjudicative administrative stage, and then you go to the magistrate who does the judicial phase of the extradition. So she is required and she's mandated by the statute in an unbiased fashion to make those findings. And it does not matter whether it is she's disproportionate, it doesn't matter if she gets it wrong, but she must be unbiased in the adjudication of that.
Mr. Hussain, oh, I'm sorry, my sister.
No, please, please.
Yes. Mr. Hussain, I wanted to go back to section 12.2. I know several times you have addressed us on it. And I am particularly interested where the section says the minister shall not issue an authority to proceed. Well, one, if it appears that the order for extradition concerned should not lawfully made. I see that as one. And then two, would not in fact be made. Could you assist in accordance with this act? Could you assist how you see that being interpreted, that the order for extradition would not in fact be made?
Well, I say two things there. The minister is not confined to the provisions of the act and the sections identified. The minister has to take into consideration all the law in respect of which is entitled to take into consideration. For example, the minister has to ensure that she as the minister is not biased. That is a requirement of the law, and that is something which she has to consider. So therefore, what you do is when you go to section 12.2, what you do is look at the sections of the act, the various of the sections of the act, in which an extradition could not be made. For example, if she finds that the issue of the specialty is not satisfied. In other words, there's no common offense in both countries. And she does that by looking at the treaty and looking at the request. And she says, look, this is not an offense in Guyana, so I'm not going to make this ATP. Or if she says, for example, this is not an extraditable offense mentioned in the treaty, is not identified in the written treaty, I'm not going to make this extradition request. Or if she says, for example, in the case of Warner, number 2, which the decision has not been handed over, which she was freed, in which there was no specialty arrangement made.
Unbeknownst to the magistrate.
Unbeknownst to the magistrate, because what happened is that the council represented to all 3 courts that there was a specialty arrangement, and the specialty arrangement is contained in an arrangement. In an arrangement between the states, and there was no specialty arrangement. And the court freed Mr. Warner on the basis of the fact that there was an abuse of power. And the fact is that there was no specialty arrangement that was made. So therefore, that is a real and genuine check on the extradition process. The minister has a preliminary look at these things. She adjudicates on it, she assesses it. She may not do so like a court of law, but she has to be satisfied that those critical ingredients are there in order to issue the ATP. The issuance of the ATP is not the issue alone of merely signing a form. It is a satisfaction that all those 4 ingredients or 5 ingredients are satisfied in respect of all of those sections before she issues the ATP. I'll give you an example.
Before you give the example though, because I know your time is going, I don't want it to run out on this, but there was something I'd like to hear you on, Mr. Hussain. You mentioned in answer to my sister, Justice Ononu, that the minister may not be making a binding legal decision, but she is making a decision which will impact on the rights of an individual. And I think that I'd like to hear you a little more on that. I wanted to know as well if the Court of Appeal of Guyana dealt with that issue of the rights of the individual and how the minister's issuing of the ATP impacts those rights. And if you could tie that up with your allegation of, I take it, apparent bias, presumed or apparent bias.
Well, the Court of Guyana did not address that issue. The Court of Guyana did not address the issue. The Court of Guyana says that it was...
The Court of Appeal.
The Court of Appeal
Yes,
of Guyana. The Court of Appeal of Guyana says that it was a pure administrative function. The Court of Guyana, the Court of Appeal in Guyana did not address the various allegations of bias made, and they skipped that issue. And the Court of Guyana disregarded fundamental impact that Section 12 would have on the proceedings. And the Court of Guyana did not take into consideration that the Section 12 right is a procedural right, which is preliminary according to guarantee, which provides a procedural fairness, and which is a right which is consonant to the equivalent of the protection of the law. Because what you're doing is you are denying the person the protection of the law provided by Section 12, which is a statutory right given to you to have an unbiased adjudication on this issue. It does not matter if the adjudication is right or if the adjudication is wrong. It is the standing of the person, the decision maker, who has the duty to adjudicate on these issues and to assess these issues. And those issues are identified in the Act because Section 12 says, in accordance with the Act, and I've identified those sections which the minister has to take into consideration. And therefore, if she's not given that right, he's denied the protection of a statutory right given to him.
You said earlier, Mr. Hussain, that the minister must make sure that she is not biased. That's an interesting way of putting it. You would agree that the Act allows for the government to authorize proceedings for extradition against persons who are in the political opposition, would you not?
Well, our case was never because you're a political adversary that the minister can't adjudicate in respect of Section 12. That is not our case at all. Our case is that having regard to what is said by the Attorney General who advised the minister on the form, and therefore he must have been satisfied that all the requirements of specialty, all the requirements of double criminal.
Yeah, we understand the requirements, not to interrupt you, Counsel. But I did think that when I read the Court of Appeal judgment, and when I read some aspects of your submissions, I thought you were saying that by virtue of the office that the minister had and the connection between the minister and the government, the minister was automatically disqualified from granting the ATP. Am I wrong?
We put it differently, in respect to this. We are saying that the minister, first of all, was present, had a collegiate relationship, had a fraternal link with the president and the vice president, who attacked the courts, who attacked the fact that these people are criminals, they are murderers, they are robbers, they are thieves. This is just not pure political banter. This is the environment in which the minister operated. She was at those meetings. She belonged to that party. She belonged to that cabinet.
Yes.
Is that the policy?
Yes, I hear you. I'm not sure if this is part of what Mr. Ford will address.
No, that is part of.
That is part of what you are addressing. Okay. So I understand that, and we may very well come back to that in due course. But I just want to ensure we are on the same page.
One issue there which I may feed into.
Sorry, if I could comment and then you respond.
Yes,
I just want to make sure we're on the same page, because by definition, if a minister has responsibility to authorize proceedings for extradition against a political opponent, it is not difficult to infer or to suggest, better word, that the minister is biased, because there's almost always the case that there's going to be some kind of political, perhaps, advantage, political implication of the government authorizing the extradition or proceedings for the extradition of a political opponent. So that is the structure under which we operate. That's the architecture of the statute that we have to face. And therefore, a minister exercising the powers granted by the statute could not, by that fact alone, be said to be biased such that the minister cannot exercise those functions.
I agree with you absolutely, my lord, except in this case, we say that at least 35 occasions, almost as a matter of policy, where criticism during an election campaign and following an election campaign were directed against these two individuals: sedition, treasonous behavior, flight from extradition, tax evasions, and criminality. So therefore, what makes this case different from a normal minister is the extent of the vitriolic statements meted out against these persons. And in that situation, there's an exhibition of bias. And the exhibition of bias continues after the ATP was issued, and the courts are entitled to take that into consideration on the basis of conjoint, where the court took into consideration after.
Counsel, on that point, and this is of interest to me, your entire case about bias is on that.
I beg your pardon, I'm not hearing
I
you.
said your entire case on bias is built or based on what the complaint is that the politicians who are now in ministerial position, public office, what they said against your client. And you mentioned at least 25 occasions on the political hustings. Now, here's my question. As I read the materials, your client said that he is the foremost critic of the government since June 2024. Now, here's the interesting thing about that. And references were made to some of the things he said. He even suggested for people to look at Facebook material. Our legal staff were able to pull up some of those for us to see. And he doesn't describe precisely in his affidavit and your submissions the terms in which he had been criticizing the government since June 2025. But on looking at some of the videos we saw, it becomes apparent that he alleged corruption and mismanagement against the government. Now, I'm not interested in inquiring in the facts of that, whether or not corruption or mismanagement occurred. My question is this. If a political opponent accuses another political opponent of corruption in office, what does that person making that allegation expect from the opponent that has been accused of corruption? Here's where I'm going with that. You and I were lawyers. We know about that concept of provocation. Is it possible that, I'm asking a question now, I'm not making a conclusion. Is it possible to say that your client might have drawn that speech fire, as it were, when he started, or when he called the government corrupt? Is the government entitled to reply in kind? That's one question. Another factor to this is by June 2024, when he said he emerged as the foremost critic, that was a whole 11 months after a certain publication of allegations against him made by Reuters News in an investigating reportage, where they blatantly accused him and his father of criminal conduct. That was in July 2023. So almost a year later, he emerged as the foremost critic of the government, calling them corrupt. Does that give a color to this case in any way?
Well, I've three answers there, Milan. The first answer is that the court is focused on the decision maker. And my client is not the decision maker under Section
But could he
12.
have provoked the circumstances that are now being referred to as bias against him? Because in 2023, from what I'm reading of the materials in this case, they were not an opposing camp, they were supporters of the government. They say that. He says that, and I believe there's a video where his father also says that. They were strong supporters of the government. They helped the government get elected into office. A number of issues come out of that. Did this allegation of corruption, was it since June 2025 that the government started being corrupt? Or the reason all this is important is because the Attorney General, the respondents are arguing that the appellants are now trying to use politics as something of an immunizing effect for them. so that when you hug politics, then you can say, sorry, you cannot extradite me because I'm a political foe. The question is, was this political foe enmity? Was it implicated in the circumstances in which that enmity arose?
Okay, I think we have the question. Counsel?
Well, could I just answer those questions, Madam? The first issue is that the decision maker is not the opposition. The decision maker is the minister. And the minister's fraternity is the one who made the statement that were biased. That's the first point. The second point is that the statements that were made were pro-extradition statements even before the ATP was issued. And that is what you need to focus on. That's the second point. The third point is that the statements by the government cross the boundary of political banter. Because what the learned friends have sought to do is to temper down or reduce the extent of the criticism and the allegations of sedition, treason, flight to Venezuela, cohorting with a country that is almost in an adversarial relationship with Guyana, that is Venezuela, and their claims to the territory, and therefore the criticism will cross the boundary of political banter. Now, the fourth point is that, my Lord, we are not asking you to assess, and respectfully, the court may not assess the Reuters report or any allegations made in respect of these applicants, because to assess the banter back and forth is not the issue. The issue is whether the minister and her fraternity cross the boundary. And the final point I want to make, dear Millard, is that the minister received the advice of the Attorney General, who had gone on record as criticizing not only the magistrate, but also criticizing the entire speed at which the extradition proceedings were taking place. And the Attorney General himself said that he advised the magistrate. Now, in the light of that, advised the minister, I beg your pardon. In the light of that, if the Attorney General said, I helped her and advised her in filling out the form. The filling out of the form is a satisfaction that all the matters which the minister had to consider under Section 12 have been satisfied, extraterritoriality, specialty, etc., etc. And if certification and all that, if it is that if that form is filled out, the minister is satisfied. The participation of the Attorney General in that exercise makes him almost a party to the decision and a party to the dais, especially when he advised on the case law, he advised on the form, he was a legal advisor, he participated in the vitriolic criticism that crossed the line, he commented adversely on all the extradition matters, even before the ATP was issued. He said the Americans had enough evidence on them. And
Now,
therefore,
Counsel, yeah, I think we have you. But you're in a place I wanted to have visited, because I wanted to have asked you whether your position would not be much stronger if one of the persons who you point to as uttering these statements was in fact the Minister of Home Affairs. So I think you've identified three persons in the government, highly placed in the government, who, in your view, made remarks which went beyond the boundary, so to speak. But none of those three was the Minister of Home Affairs. So I'm asking you whether you would not be in a much stronger position if the Minister of Home Affairs was one of those three persons.
Well, I take you the case of Hello Millen. In that case of Hello,
right.
Fatima Hello, right? Now that was a case in which allegations were made against the judge who belonged to an organization where he was very deeply critical of Muslim Palestinian Jews. the statements made in a magazine which and an organization which he belonged to. So therefore, he belonged to an organization. The organization published articles that were very detrimental to the applicant because of her race and described that particular situation in Palestine in very pejorative terms. And Lord Mann said that if it is that those statements are in fact made, that it would be sufficient for disqualification for the judge to have taken. In other words, he would have to disqualify himself. So it is not the person who has made the statement, it's the fraternity where you belong to. So therefore, argument of our case in respect of the Minister of Home Affairs was follows. First of all, she was present at all of those meetings and spoke. Secondly, she belonged to that fraternity. Thirdly, she had to have at least heard it and accepted and believed in it because that was part of the campaign. She wore the campaign jersey. She associated herself with those persons. She took advice from the Attorney General in respect of that persons. And in one instance, she mocked the second name applicant.
Or Mr. Hussain, I think we are getting tight on time and we understand what you're saying. So that what I want to, President, if you would allow me to intervene, if you have finished. If you have not, I'll wait until you're finished and then intervene.
No. I was going to make the very point you made, my brother, that we will have to move on pretty soon because we do want to hear from Mr. Ford, of course.
Yeah. So if
Yes.
I'll be short in what I want to ask. So Mr. Hussain, you have framed your client's positions as in a sort of reductionist way, meaning this. Because of the fraternity argument, no one on the government's, on the executive side, because this minister or any other minister would be on the hello case, they broke the fraternity argument, be infected by the bias of these three senior people who you've identified and for the reasons you've given. We don't need to rehearse the facts. Is there a more pragmatic and reasonable middle ground where to honor procedural fairness, to recognize that accepting for the moment your contention, it is bias and not the open mind, genuine decision maker sort of threshold, recognizing and acknowledging that bias infects the process, irrespective of rationality or proportionality of the substantive decision. Is it not a more pragmatic and reasonable middle ground to say that where there is evidence that a particular decision maker is infected, in this case, maybe because the direct advice was from the Attorney General, or as the President has said, this minister made similar remarks, to say such a person would not be impartial and independent decision maker. But it is not to go so far to say no one can ever make such a decision on the current executive side. Would that? And the reason I ask that, I'll just finish quickly and then allow you to respond, Mr. Hussain. The reason I ask that is because we have to also, I think, operate within the social context of pragmatics. That is to say, we operate in a system where we want criminality, if it is reasonably being prosecuted with all the various standards, we want to prosecute criminality. We want to facilitate proper extradition proceedings. That must be a proper policy of rule of law and governance. However, we want to balance that against processes that may be tainted for public trust and confidence, rule of law, protection of law arguments. I get all of that. Why is there not a middle ground where, if that is raised, as you have at the first stage, before time, energy, expenses have gone on, for that determination to be made. And as in judicial review, a legitimate option is reconsideration before a different and more impartial and independent decision maker.
Absolutely, Millard. Absolutely. And my little friend, Mr. Ford, will address the Kaltuna delegation, will address the issue of some other person can do it. There's no reason why. In the case of Froome, that decision is routinely taken.
So that for
by-
you, thank you. So for you, your outcome on this is not that this must be quashed in.
Absolutely not. Millard.
It is simply that this particular reference of the ATP infected, the minister being infected by the Attorney General in particular, because of what you allege. I'm not suggesting I think that way, that makes it corrupt. I use that technically, I don't mean it otherwise, a legally corrupt decision. And therefore it should be remitted to an impartial and independent alternative decision maker for reconsideration. That would be acceptable to you and your client?
Absolutely. That has been our case all along the way, Millard.
No, but I misunderstood you. I apologize. I thought
Okay.
your contention was there could be no possible.
At the Court of Appeal, we're not saying that this is the end of the extradition at all, or the request. What we are saying is that exactly what Millard has so eloquently put, that another official who is not biased could do it under Kaltuna, under the Interpretation Act, and Millard from Mr. Ford will address that issue.
All right, thank you.
Yes, you said Mr. Ford will address that issue?
Yes, Millard.
Wonderful. So if you don't mind, Mr. Ford, I think we are all ears. Now, I think we have asked so many questions of your colleague that it would not be fair to leave it on the 4 minutes. So we are going to give you some more time, but please be as concise as you could be, please. Thanks.
I just kind of one point before I leave, Millard, and that is I think you have brought it. There are two ways of approaching this issue. The first way is the way that the learned friend has suggested. And in all of those cases, those are policy positions. In the cases, Imperial Oil, Franklin, those are policy issues. Those are political issues, political promises. Those are developmental issues. Those are environmental issues. And in that case, what you have is a minister approaching the matter with an open mind, and the cases all speak to that. This is a case about rights and interests, and therefore, what happens is in that situation, this is a case that has to be approached from the point of view of bias, whether apparent bias or presumed bias, and therefore, an anxious scrutiny according to Burgundy and according to Ferguson and Galbraith, I think, and Froome as well, anxious scrutiny of the rights. And therefore, that is the distinction. The distinction is that you can't tamper down what it is that the state has, what the state actors have said in the matter. But what you can do is you can apply the appropriate test, not approaching the issue with a clear mind, but understand it is adjudicative or non-adjudicative, applying guarantee and delegating the power to someone else. And that is essentially what our case is. The approach is different, and Mr. Mendez's cases all deal with a clear mind, with a statute, with a minister dealing with planning.
Yes, I'm sorry, I don't mean to be disrespectful, Council, but I think you have made that point before, and you have now left Mr. Ford with 2 minutes. So,
thank you very much, sir.
Thank you, sir. Yes, Mr.
I'm going
Ford.
to give Mr. Ford my seat. I apologize for interrupting.
No need to apologize. That's fine, sir. Thank you.
I'm a very enthusiastic person, and
Please, sir.
Good morning, Your Honors. Your Honors, just to continue from where Maloney Senior left off, sorry, and the questions raised in relation to the issue of delegation, it is not our case at all that because of what would have transpired, that this means that this is the end of the extradition proceedings. And I was very heartened by the question asked by Justice Jamada, because it positioned our case in a very practical and realistic way, a way that has not been captured in the decision of the Court of Appeal or at first instance, where our arguments have been portrayed as one in which we're simply saying that this bias, no other minister could deal with it, and that is simply the end of the matter. Your Honor, we have cited and relied on the Section 27 of the Interpretation Act, which we believe provides a broad and general power for the minister to delegate statutory functions under the Fugitive Offenders Act. The Fugitive Offenders Act does not prohibit, either expressly or explicitly, the possibility of a delegation occurring, let's say, by the very minister. Section 27 of the Act, Your Honors, provides the power to delegate. It's been the argument on the other side that what we contemplate is an ad hoc delegation. Bearing in mind the approach to be very realistic, we believe that the section permits a delegation for the purposes of the case. The minister is entitled after the completion of the exercise of that delegation, that function, because of the peculiar circumstances of this case, to revoke the delegation if they wish, and to resume the full exercise of the powers vested in the minister on
May I ask you, Mr. Ford, is the power as you conceive it to delegate at large? Can the minister delegate to anybody?
The section says, Section 20.
Yes, we're familiar with the section, but I'm just asking you whether the minister could delegate to anyone, or would it need to be another minister? Because as you know, the FOA speaks in terms of the minister exercising certain functions.
Yes, sir. Yes, Mr. President. Your Honor, the section refers to the exercise of the delegation by the minister to any public officer. Section 27 refers to the exercise.
Mr. Ford, after you finish the president's question, I would like you to go to Article Section 6 of the FOA and see whether that gives us a context. But finish the president's question first.
Section 6.
Unless you're finished.
Section 6.
Yes. See whether that tells us anything now about how to read Section 12. Section 6 says, here is about the certificate from the Minister of Foreign Affairs. And it said certificate issued by the minister assigned responsibility for foreign affairs or on his behalf by any other person authorized by him. So you see Section 6 explicitly recognizing that in the case of Minister of Foreign Affairs, explicitly saying or on his behalf by any other person authorized by him. But Section 12 doesn't say that. Are you saying that the Interpretation and General Clauses Act is a cure-all?
Yes, Your Honor. I say that Section 27 of the Interpretation Act, notwithstanding the difference that Your Honor would have pointed out between Section 6 and Section 12, whereas Section 6 specifically confers on the Minister of Foreign Affairs the power to have someone authorized by him to issue the certificate. Section 27 of the Interpretation General Clauses Act is broad enough, Your Honor, to permit the delegation by the minister to any.
But the minister looking at Section 6 and 12 may well say, well, since section 12 doesn't say anything of the sort, as we see in section 6, I am not free to delegate. Because section 12 should have told me the same thing it says in section 6, but it doesn't.
I
That's a
agree.
question for you.
I agree, Your Honor. But Your Honor, that position would be very and unduly restrictive and not take into consideration section 27 of the Interpretation Act, which says where any written law confers any function on the president, the minister, or specified public officer, the president, the minister, or the specified public order or officer may by order delegate any public officer to exercise such function. So section 27 is a very broad section, which would effectually be taken to be read as part of the as part of the Fugitive Offenders Act, which would have the same effect as section 6, because it would imbue the minister, the Home Affairs Minister, that is, with the similar function and power to delegate as expressly set out in section 6.
Mr. Ford, can we interrogate the question? It began with the president in a slightly different way. In the act, the FOA, where is the minister defined?
It's not.
Your Honor, that is one of the issues that I wanted to deal with as arose this morning. There is no specific section in the act which says that it must be the Minister of Home Affairs. It simply says the minister. The Court of Appeal of Guyana in the King's case said that by tradition and by general understanding, the specific function is to be exercised by the Minister of Home Affairs. So that is how the whole issue of it being the Minister of Home Affairs. As a matter of fact, Your Honors, and you would have read in the submissions of Mr. Mendez, he has basically extrapolated from that by virtue of the fact that we would have written letters to the Minister of Home Affairs, that we would have gone into a situation of waiver, and we would have been duty bound to acknowledge the Minister of Home Affairs as the person to exercise the section 12 functions in relation to the issuance of the ATP, which is another issue which I'll deal with. But Your Honor, there's no specific section in the act which says that it must be the Minister of Home Affairs.
So that is, so I raise that because that would be in contradiction to section 6, because section 6 is referring to a certificate by a minister whose roles and responsibilities are described, i.e. responsibility for foreign affairs. So
yes, sir.
section 6 clearly points to a minister who has in their portfolio responsibility for foreign affairs. You would agree with me on that, right?
Yes, Your Honor.
It would appear that section 12 does not do what section 6 did, and which section 12 could have done, I imagine, because section 6 did it, and suggest any sort of responsibilities. That's what I was trying to get at. Is there anywhere in the Act that does what section 6 does, which sort of points to the responsibilities that are in a portfolio when it speaks to the minister?
Your Honor, there's no section in the Act which assigns or identifies or describes in any way the portfolio of the minister referred to in the Act as a minister.
But Mr. Ford, the minister under section 12 surely cannot be any minister in government, because that would then mean that the Minister of Environment could be dealing with extradition, because the provision says the minister. Doesn't it mean that the Minister of Finance can make that claim? So there has to be a way of rationalizing what minister means in section 12, isn't there? And how do we do that in the absence of a definition?
Certainly, and I agree with you, Your Honor. Under the Constitution, the President is the repository of all ministerial authority. The President can assign a wide range of portfolios to specific ministers. So it is the minister the president can assign that portfolio to any minister. So we may end up with an amalgam situation where the Minister of Foreign Affairs and the minister, it is also the minister who has responsibility for extradition. It is possible under the constitutional scheme. The president also could decide not to identify a minister.
Mr. Ford, that's what I was trying to get at. Don't we have to look in the ministerial portfolios for the relevant roles and responsibilities then? In other words, you can have, suppose there was, the president can create any ministry. Doesn't have to create a minister or a Ministry of Home Affairs. But what we may have to look at is the roles and responsibilities, just like in foreign affairs, right? So the question is, when you look in the relevant portfolios, is it that the Ministry of Home Affairs is the one who has the roles and responsibilities that most align with the treatment of extradition proceedings? In Guyana right now, that's what we're asking, I think.
Yes, I would invite you to answer if you can, but do bear in mind that we have limited time, and I'm not quite sure where this particular issue is leading. But please, yes.
Your Honor, I must concede that I cannot specifically recall what are the specific statements set out in the ministerial orders issued by the president after the last elections in relation to the allocation of this specific responsibility. The case has, however, proceeded on the basis by virtue of the exercise of the function by the minister, on the basis that that minister, Ms. Wonich Waldron, the first name respondent, is the minister who has the responsibility historically, and who, by virtue of the exercise of the function, is presumed to have been the minister imbued with the authority. We have not specifically challenged the issue of the exercise of that minister by virtue of portfolio, from a portfolio perspective, Your Honor.
So nothing much turns on this, does it? I'm just trying to follow the issue. Where we got into this, but I was asking you whether there was any restriction on the ability of the minister to delegate. And you said that the minister can delegate to any public authority. Was that it?
Yes, Your Honor. And section 3.2 of the Interpretation and General Clauses Act says that the act shall apply unless expressly otherwise provided to all written law. So it reinforces my point I was making.
Right. But my brother, Justice Ibu Osuji, raised, I thought, a very interesting point, because you were saying that there's nothing in section 12.2 that would suggest that section 27 is not applicable. Whereas he pointed to another section in the FOA 6, which clearly allows for somebody else other than the minister to participate in the functioning of that section. And section 12.2 does not have an equivalent provision. So I suspect by implication, the question is, or the proposition is that section 12.2 does not allow for the application of section 27.
And my answer, Your Honor, is that the Interpretation General Clauses Act, specifically by section 3.2 and by section 27, does exactly the same thing as what section 6 does expressly in relation to the Minister of Foreign Affairs, in that it specifically provides for the delegation by the minister, whoever the minister may be, who has functional authority or superintendence over the matters of extradition, to engage in a delegation. The section says that this act shall apply to all laws, and section 27 specifically says that the minister, the president, shall have that power to delegate any function under law, under the law being, of course, section 12, to delegate that power to a minister, so the public servant. So effectively,
we have your summation on that, not a difficulty. Could I just ask you, with the decision of the minister to delegate, given your point of view that the minister could delegate, would that then be subject to judicial review? If the minister delegated, in this case, her functions to another minister, would not the problems that you have with the current minister also arise there?
Your Honor, interestingly, Section 27 does not permit the delegation to another minister. It permits delegation to a public officer, which in the context of, it may be interpreted to include by definition a minister, but my interpretation, Your Honor, which is favorable with a realistic, fair and just determination of this case, in view of the principles outlined by Justice Jamadar, the need to have criminal processes flow, while at the same time protecting rights and having a balance. It is nothing prohibiting, Your Honor, the minister from exercising the delegation power to delegate it to a public officer.
Of her choosing.
Other than a minister.
Yes, I'm not quite sure where there's that limitation, but in any event, what I'm asking you is that the minister, under your theory, can delegate her powers to any public officer of her choosing.
Yes, Your Honor, and that is exactly.
Would you not have the same kind of issue then, Mr. Ford?
No, Your Honor, because, Your Honor, in the case, for example, not exactly in the same antecedent facts, but in the case of Froome, the minister delegated to a lawyer in the ministry in Canada the power to issue an ATP, and the court upheld the exercise of that delegation and the validity of the ATP in that case.
Is that included in your submissions?
Yes, Your Honor.
Yeah, thank you. Okay, we'll look at it. Thank you very much. I think we follow you on that point, Mr. Ford. Is there any other point you wanted to urge on us, either in delegation or otherwise?
Just truly discretionary factor that she could have taken into account. Peculiar to the minister.
Your Honor, so we would have relied both on the very Interpretation Act and the Cartona principle as expressed and upheld in the Froome case. As a matter of fact, it's at paragraph 8 of our affidavit, of our applicant's reply to the Attorney General's submissions. He specifically referred to the Froome case and to the paragraph 139 upon which we rely in that decision. So there's no need for me to read it. And we also refer to, Your Honor, to the fact, to the Burgess case, where the court recognized the Cartona principle as not being either one of agency or not strictly one of strict delegation, but the person would be in effect exercising the constitutional power of the minister. Your Honor, nowhere in the decisions, both at the first instance or in the Court of Appeal, did the court engage in any analysis as to the possibility of delegation. The court felt that Section 27 did not permit a delegation at all that would be capable of being executed and implemented. In these circumstances, the court did not consider any question in relation to the applicability of the Cartona principle in relation to the implied power to delegate by the minister. I don't think that I could do much more having regards to time in relation to the delegation questions, Your Honor, unless there are any further questions.
I think we understand you fully on that point. Mr. Hussain said you'd have dealt with the issue of the test as well for special leave. Did you want to say a few words about that?
Oh, yes, Your Honor. Your Honor, before just going to the question of special leave, I'd just like to stitch in quickly, just a quick point on the issue of waiver and necessity. Your Honor, flowing directly from our arguments on delegation and the Cartona principle, it is our submission that having regard to these principles, the question of the doctrine of necessity does not apply. We relied in our submissions on the case of Metropolitan Fire against Churchill at paragraph 10 of that very reply submissions to point out that it has said in that case, and it's a matter of common sense and prudence, that if there's another person or entity to make the decision, the whole question of necessity would not arise.
You are on hold. I'm not sure why. Are you answering another call? Ah, you're back. Yeah, we are back. You're back with us now, Mr. Ford, please.
I apologize, John. I think we lost communication for a few seconds there.
Yes, no, that's fine. Please go ahead.
Can you hear me, Your Honor?
We can hear you and we can see you. Please proceed. Yes.
Maybe he's having technical
Are you hearing me, Your
issues.
Honor?
Yes.
If you're hearing me.
We can hear you, yes.
No. You're saying that they hear me. So let's
Yes.
continue.
Yes.
Let's go. Your Honor, so in the case of the Metropolitan case, the court identified a test in relation to the applicability of the doctrine of necessity. And the court said that the court must consider all the justice of the case. And the court actually outlined a criteria in relation to the conduct of the parties, including the conduct of the parties in relation to the applicability of the doctrine of necessity. And this is paragraph 11 of our reply submissions. But interestingly, Your Honor, paragraph 160 of this case, the court focused in on the question of the conduct of the adjudicator in relation to the questions of whether the doctrine of necessity must be applied. And we respectfully rely on this, Your Honor. The court says that where the issue that is the source of concern as it stemmed from a result of the conflict of the voluntary collateral act of the adjudicator. Now, those are circumstances which would point to the inapplicability of the doctrine of necessity in those circumstances. And in this case, Your Honor, having regard to all that has transpired, to the statements made, and I just wish to add that we have complained of about 30-something statements, 35 statements. They cover a wide range of things. But among the stuff or the content of it, Your Honors, there are specific statements by the President, the Vice President, and the Attorney General that go directly to the issue of extradition. So there may be statements which the court may feel that are substantially that of the political battle and back and forth. And we would understand that, but we still say that in relation to them, they show bias. But if we distill them here, there are sufficient statements made by the persons identified that go directly to the question of extradition, statements prejudicial to the question of extradition, statements showing a fixed understanding and comprehension in their minds that extradition is to take place many months even before the extradition process would have commenced, and it would have continued unabated, specifically led by the Attorney General.
And remind me how is this connected
would have criticized the magistrate continuously in relation to the issues. And I know you would have heard us on that, and you would have read what we would have said in relation to those matters. The other question that I really wish to raise here is that of waiver. Your Honor, the respondents have raised the question of waiver, and they rely on their cross notice of appeal in this matter. It's very interesting, Your Honor, that paragraph 2 of the cross appeal, they have identified their concern in relation to waiver. They've said that the applicants waive any right to object to the issuance of the ATP when by correspondence issued by then counsel for the appellants regarding possible imminent extradition. No objection was made to the minister exercising her power to issue the ATP. The first point we wish to make, Your Honor, which goes without saying, but we wish to make it nevertheless, that the burden of proving waiver lies on the respondent. And in this case, they would have failed to do so. In order for waiver to operate, it requires that the party would have acted freely and with full knowledge of all the facts. And in relation, that is the Pinochet expression of the principle. And in the local bill case, that the applicants with full knowledge of all the facts relevant to the decision, waiver or not, would have acted. Your Honor, in this case, the evidence shows that in relation to the Attorney General at least, his involvement was only made known to us, was never disclosed by the Minister of Home Affairs, by any other person, but was only made manifest when an affidavit in answer of defense was filed in the very proceedings in the High Court. So we respectfully submit that we clearly did not have or could not have all the information required, all the relevant knowledge and all the relevant facts within our client's knowledge or awareness at the time of the 31st of October when the ATP was issued. Your Honor, the letters relied on by the learned friend, Mr. Mendez, do not.
Mr. Ford, can you hear us?
5 minutes.
No, he cannot.
Do not
I'm trying to convey to
that is
counsel
any
that he has
disclosure
5 minutes
of any
remaining.
unequivocal election by us. There are 2
Registry, could
letters
you
simply
attempt to assist,
asking
please?
for domestic investigations, and the other one asking for indicating that my clients will not abscond the extradition process. They do not indicate any unequivocal abandonment of any rights. Your Honor, in relation to the question of the
Your Honor, may I
principles
suggest that
that
we
would govern
pause so that Mr.
special leave.
Yes,
Ward can hear what you're saying?
yes, I think that's a fair point. Thank you, Mr.
We
Mendez.
respectfully, Your Honor,
So,
rely on
Madam Deputy Registrar, we will pause for 10 minutes and come back to hear the
we
end of
respectfully
Mr.
rely
Ford's
on the
submissions.
authority of Lynn Mining.
Thank you,
Mining
Court Adjourned. We will
Enterprises,
try to
where
contact
Justice Barrow
Mr. Ford
pointed
and
out
Mr.
clearly.
President. Thank you.
Can't take it no more. I can't take it no more. Can't take it no more. Imagine 18 hours of blackout and you're telling people progress. Cost of living gone up 100%. Yet you give public servant less. Mr. President, listen to the people. Search your soul and you will confess. I want you try surviving on the public base. Then you're gonna know but stress. Cause I done fed up. You done fed up. He done fed up. She done fed up. We done fed up. The people fed up. You're hiding corruption inside the cup. Look how evil set up. The people fed up. They don't drive no fear with the citizen. They may want the people speak out. Freedom of speech done gone inside the gutter. Knock off when you open your mouth. Discrimination in entertainment. And you're talking about one Guyana. When the Ministry of Culture keep the big shows. One set of girls and banner. Cause I done fed up. You done fed up. He done fed up. She done fed up. We done fed up. The people fed up. You're hiding corruption inside the cup. Look how evil set up. The people fed up. Every picture you take and promise you make, everything you do is about clout. Then you come into me for I shake your hand, there's nothing to smile about. Corruption inside every sector, but when it comes to them, they send you. Try when you open your mouth. Discrimination in entertainment, and you're talking about one Guyana. When the Ministry of Culture keep the big shows, one set of girls and banner. Cause I done fed up, you done fed up, he done fed up, she done fed up, we done fed up, the people fed up. You hide the corruption inside the cup, look how we evil set up. The people fed up. Every picture you take and promise you make, everything you do is about clout. Then you come into me for I shake your hand, there's nothing to smile about. Corruption inside every sector, but when it comes to them they send you. Try investigate efficiency, right? Go talk to Barrett and Sue, cause I done fed up, you done fed up, he done fed up, she done fed up, we done fed up, the people fed up. You're hiding corruption inside the cup, look how evil set up. The people fed up. I done fed up on the dirty water, low pressure, want scream and tell somebody. Imagine 1,500 US, and they're telling me super salary. I done fed up on the unemployment racism and the lie they say one Guyana. Cause when you look with the oil money going, circulate with one set of banner. Cause I done fed up, you done fed up, he done fed up, she done fed up, we done fed up, the people fed up. You're hiding corruption inside the cup, look how we evil set up. The people fed up.
PPP will take care of you from erection to resurrection. A quick one for you. And the last time I said that, somebody came up to me and said, man, you little bias. Erection is a man thing, what happened to the women? So I got a woman thing for you. And hear me? From
oh, Jesus Christ, if cost of living double, I don't know what happened. A pound of sugar is $300 already. Flour, everything gone up. Everything just raising. You gotta give a $40,000 for buy good ration. You gotta get 3 man now. A weekend man, a monthly man, and a fortnight man.
Discrimination in entertainment, and you're talking about one Guyana. When the Ministry of Culture keep the big shows, one set of girls and banner. Cause I done fed up, you done fed up, he done fed up, she done fed up, we done fed up, the people fed up. You're hiding corruption inside the cup, look how we evil set up. The people fed up. Every picture you take and promise you make, everything you do is about clout. Then you come into me for I shake your hand, there's nothing to smile about. Corruption inside every sector, but when it comes to them they send you. Try investigate efficiency, right? Go talk to Barrett and Sue, cause I done fed up, you done fed up, he done fed up, she done fed up, we done fed up, the people fed up. You're hiding corruption inside the cup, look how evil set up. The people fed up. I done fed up on the dirty water, low pressure, want scream and tell somebody. Imagine 1,500 US, and they're telling me super salary.
asked at the beginning to Mr. Hussain. Your Honor, we first learned of the issuance of the ATP on the 31st of October when our clients were brought before the magistrate's court. We had no knowledge that the minister had intended to issue it or had even issued it. On that occasion, on the 31st of October, myself and Mr. Dujon, who's sitting at the table here with us, indicated to the court that we felt that the ATP was invalid on the ground of bias. And we had thereafter, at the commencement of those proceedings, we launched a request for referral to the magistrate, by the magistrate to the court, to the High Court in relation to a number of constitutional issues. The magistrate refused those referral issues, and within 2 weeks of the referral, these proceedings were filed in the High Court. Your Honors, whilst the court has asked the question as to whether these issues could have been dovetailed and form part of the habeas corpus proceedings, Mr. Hussain did make a number of points, which I just wish to supplement quickly. First, we believe that at the basis of this case is a question of fundamental rights. We believe, even though that it is a judicial
review. You really need to go over what Mr. Hussain said at such considerable length and upon which he was examined so closely, do you?
Your Honor, I am just adding something, Your Honor, because the question.
So he missed out something. You go ahead then.
Yes, Your Honor. The question was raised as to whether we could have raised the question at the point of the habeas corpus proceedings, and that was my understanding of the question. We believe, Your Honor, that in that context, it would have been a fair response by the respondents to raise then the question of delay in relation to that issue. We would have been met with the question of delay. Secondly, Your Honor, in the Fuller case, the court specifically, the Privy Council specifically said that the question of bias and abuse of process are not questions to be ventilated in the magistrate's court. And in a slightly different context, the decision of the Court of Appeal of Belize in Leach, as I recall, the Court of Appeal of Belize indicated that the respondents to an extradition proceedings must be given every opportunity, and at the first opportunity, to raise challenges which goes to the proceedings. So I just wanted to condition and add our response to waiver and to the question as to whether it could have been deferred to a later stage, coupled with the fact, Your Honor, that this is clearly a rights case at its essence, and I wish to adopt the position of Justice Jamadar in the case.
I don't think, with respect, the judge had a position. I think he was asking a question.
No, I wish to adopt Justice Jamadar's position in the case in which he articulated the position that in the context of Caribbean constitutional law and Caribbean judicial review, that it must have and bear effect in relation to the constitutional rights. So we believe that...
Counsel, when we lost you, you were making a point about necessity that I would like to ask you one question about. Would you mind, President, if I
Yes,
that
please.
little question? In your submissions on necessity, you referred to a case, I missed it, but you say the point of it was that where the adjudicator had effectively set up, put himself or herself in the position of bias or compromise, that the doctrine of necessity would not apply. Did I understand you?
Yes, Your Honor.
All right. My question is, does that by parity of reasoning not work in the other direction as well? Here's what I mean. When your colleague was speaking, I raised the question of clean hands. We know that doctrine equity, he who comes to equity must come with clean hands. The question is, by parity of reasoning, is it possible to say that where a complainant of bias who says decision against me was biased, if that complainant is seen to not have clean hands, to have perhaps drawn the comment, can we really not use this reasoning to say, well, you are the one who waded into that pit? You can't really complain too much about it. Can you address that, please, quickly, and then, if you can, and we leave it at that.
Yes, Your Honor. Your Honor, the question of the conflict of interest, which the case sought to address, dealing with the question of necessity, deals with the conflict of interest in which the adjudicator would have found themselves in. The case does not contemplate such an expansive interpretation to permit the party who is complaining.
I was dealing with a parity of reasoning. Why does parity of reasoning not apply, apart from expansive?
I don't think so, Your Honor. I don't think so. Your Honor, just to wrap up, on the question of leave, I would say, Your Honor, that the court is well acquainted with the principles of special leave and the grant of special leave. We need to show that we have had a real prospect of success, which we believe we would have established in this case respectfully. We would have identified and relied on the case in our written submissions of Ramsahoy against Linden Mining Company, Mining Enterprises, which would have indicated the features which are necessary for the establishment of a special leave application. We believe that we would have satisfied almost all the criteria, the features explained or identified by Justice Barrow, which is well known to the court. Your Honors, this case is...
Mr. Ford, I hear you, and we have your written submissions.
Yes, sir.
I think you have spent the 5 minutes in the way you chose to spend it.
Yes,
and
sir.
we really have to move on.
Thank you very much.
But on the issue of the standard for leave, we know the position because it is in your written submissions, and I assume you're not resigning from those positions.
Certainly not, sir.
Certainly not, yes. Thank you, sir. Thank you very much indeed. Mr. Mendez, we come to you a little later than we had anticipated, but we are now with the first respondent, please.
Thank you very much, Your Honor. I hadn't intended to do so, but I think that given that the issues of waiver and necessity are fresh in all of our minds, that those are issues that would be convenient for me to deal with first, not only because they're shorter points, but also because either one of them, if decided as the first respondent has respectfully submitted, would be a complete answer to the applicant's case. As far as waiver is concerned, we have set our submissions on that point out in great detail in our written submissions at paragraphs 64 to 72, in which we set out in some detail the content of the letters written by the applicant's attorneys to the Minister of Home Affairs. And we say that those letters indicate that the applicants were engaging the minister as the minister responsible for extradition, the exercise of extradition functions. Clearly,
Mr. Mendes, if I may interrupt you, sorry.
Sorry.
Just trying to understand your submissions on this point, if you could help me. So is it your argument then, or submission, that the applicant should have brought some kind of preemptive application? So I've read your submissions with regard to the letters, the exchange of correspondence, but are you saying that there was some obligation on their part to bring some kind of litigation to preclude the minister from dealing with this?
No, that's not what we are submitting. What we are submitting is that by those letters, they engage the minister in the first respect to ask the minister to use her good offices effectively to ensure that there would be a peaceful, as it were, surrender to any warrant that might be issued as a consequence of the commencement of extradition proceedings. And in relation to the second letter, that is the letter from Mr. Hughes, as the second applicant has said in his affidavit, what they were doing in that letter was engaging the minister on the Catroni issue. That is to say, on the issue as to whether Guyana, as opposed to the United States, was the proper forum for the airing of these allegations made against them. So they say, this is what the second applicant said. He said in his affidavit that they were engaging the minister as the minister who had the power to issue the ATP on that question. And we respectfully submit that having engaged the minister in her capacity as the extradition minister, they waive their right later on to say, well, you can't make any decision in relation to the ATP because you are infected by bias. So we don't say that they should have brought proceedings. We are saying—
So, Mr. Mendes, can I ask
So
you
even-
a slightly more fundamental question on that? Is it that in instances of bias that waiver has the same sort of effect, or is it that in where there are allegations of bias because of, well, I'm not going to rehearse with you why that is important for procedural justice, etc., that this question of waiver must be looked at a little differently? Would you say that there's any nuance around waiver when bias is at stake?
The submission that we are making is on the assumption that the rule against bias would otherwise apply. In other words, the assumption of our argument is that the minister is compromised by bias, either because there's automatic disqualification or because the Mercer test, let us call it that, would be applicable and would result in a decision that the decision is vitiated by bias. The waiver argument runs very simply this way, that if you have a problem with a decision maker on the grounds of bias, then you have to take the point with the minister. If you don't take the point, then you will be taken to have waived the bias, and you cannot raise it later on. That is essentially the principle of law that is stated very clearly in the authorities.
You
So
seem
this
to
is
be
what I'm
going
saying.
further, Mr. Mendes.
I'm sorry. Your Honor?
You seem to be going further by suggesting that the applicants actually invited the minister to make a decision in their favor in relation to this application.
Exactly. So that the point is, the normal way this would operate is that you are before a decision maker in some proceedings, and you are aware of the ground of bias. You could take the point, but you don't do it and allow the decision maker to go ahead. In this instance, what they are saying is they engage the minister, and according to their own affidavit evidence, matter of fact, they were complaining that the minister did not make a decision on the Catroni factor, so that they engaged the minister knowing full well all of the facts that would give rise to this particular challenge. They knew the facts because, of course, they've now recited them in their affidavits, and they are all facts which predated the exercise of the power of the minister to issue the ATP. So that if I noticed that my learned friend, Mr. Ford, has not said or has not challenged that aspect of our case. What he has said is, or I should say, the only thing that he said that he did not know about was the advice given by the Attorney General to the Minister of Home Affairs. So leaving that part of it out of consideration for the moment, he does not appear to resist the submission that we make, that you engage the minister, you engage that minister because it is well known, and this is the evidence of the minister herself, which was not contested at all. It is well known that the Minister of Home Affairs is the minister who is dealing with extradition matters. The premise of the letters, and indeed the caption of the second letter, is request for extradition of the applicants. It is stated there. So all of these letters are being written in the context of an expected request that is going to the Minister of Home Affairs. And of course, they must be taken to have known, my learned friend protestations to the contrary, that she would be called upon at some point in time to exercise the power to issue the ATP. Yet still they are engaging her.
Mr. Mendes, I want to be clear on the timeline. I think you may have alluded to it, but let us be clear about that for the record. Yes. At what point?
This is
relative to the issuance of the ATP.
Yes.
At what point did you say these communications with the minister were made, which you now say amount to waiver?
The first is the letter dated the 6th of October 2025, and the minister's ATP is issued on the 31st of October 2025. The second letter is on the 13th of October 2025, so it's about two to 3 weeks before the minister issues the ATP. But as I said, it's all in the context of what appeared to be common knowledge that a request was in the works.
Thank you.
Now, to the extent that my learned friend's answer to this point is, well, we did not know that the Attorney General had given advice. Our respectful submission is, as the Court of Appeal held, and we respectfully say the Court of Appeal was right in this regard, that the Attorney General's participation on the facts was to provide the Minister of Home Affairs with the decision of the Court of Appeal in the King case. And as the minister says, she had sought his advice on the question of the existence of the arrangement with regard to extradition to third countries by the United States, and he provided her with the authority in King, which clearly said that that was already provided for. And the second thing that he has assisted her on is the filling out of the form itself for extradition. And it is important, I'll eventually take you to that, but the form is a very simple form, and you will see it attached to the Act itself at electronic page number 3308. And it is a form, and it is addressed to the worship, and there are about 4 blanks to be filled in. One of the blanks is the date. The first blank is, it reads, a request having been made to the minister by on behalf of blank, and obviously what you insert there is the United States, for the return to that country territory of AB. So you have to insert the name of the person who is requested, who is accused or alleged to be lawfully at large. Well, you have to strike out alleged to be unlawfully at large, because this is one of being accused of the offense of blank against the law of blank. So obviously you have to put in there what is the offense that the person is accused of against the law of the United States. So that is basically what the assistance that the Attorney General gave to fill in that form.
Mr. Mendes, that sounds very clerical. What kind of advice could the minister give, would need to give on things like your name and the country? In other words, presumably the minister could have advised or might have been asked to advise on factors beyond that as to whether her own discretion under 12 was satisfied. In other words, you're saying it's confined to this form, and this other point. But the form itself, I'm wondering, being so basic, why would a minister need to be advised on this?
Your Honor, I am addressing the evidence that has been led by the applicants. And the evidence that they led, well, first of all, the minister herself said that she received advice from the Attorney General in relation to the third party point, third country point, if I may call it that. But they relied on a newspaper report in which they quote the Attorney General as saying that he has assisted her in filling out the form. So the evidence that we have of the Attorney General's participation is the minister's evidence that he assisted her on the third country point, and their evidence that he assisted her in filling out the form. So as far as his participation is concerned, that is the evidence that we have. And as I said, I'm respectfully saying that those two bits of assistance could not possibly, and respectfully ask you to uphold the Court of Appeals decision in this regard, would not be sufficient to taint the minister's decision in any event. But we say, as far as what is said about the minister herself, we respectfully submit that, which I think Your Honors have already noted, has nothing to do with anything in particular that she did or said, but has to do with what other persons in the government had said about the applicants beforehand. That is the basis of their complaint, that she would not have been able to determine the issues fairly. We say that that was waived. And my learned friend's answer to that is, well, the Attorney General participated and we did not know. We say that if there is waiver, then that is not sufficient to undo the waiver, as it were.
Sorry, could you pause for one brief second, please, Mr. Mendez?
Certainly,
and get him moving on, perhaps. And may I inquire as to whether the Honorable Attorney General is in court?
I think so.
I'm here.
Well, I would very much like to see you, please, Mr. Attorney General. Would you mind turning on your camera, sir?
President? I think my camera is on.
President, there
Yes.
are two screens. So he's on the second screen. So if you want to see him,
Oh,
you will have
oh,
to
I
go.
see.
Yes. So himself and Mr. Gusai and I think one of the appellants and others are on that screen. So he's there, President. We are seeing him from our end.
Okay, yes, but I apologize, Mr. Attorney General. I saw another screen here, which I thought was you, but there you are. There you are.
Thank you.
Wonderful.
Thank you very much for observing my absence.
I absolutely want to
Listening,
make sure that
listening.
I'm seeing you.
Thank
Very
you.
well. My apologies,
you very much,
Mr.
sir.
Mendez. Yes.
Thank you very much, Your Honor. It's the second point that I wish to address, which I respectfully submit would be a complete answer to the claim, is the necessity point. I don't think that we are in dispute on the test itself. It is the application of that test. I understand my learned friends to be saying, well, necessity does not apply because the minister is not the only person who could have taken the decision, that decision could have been taken by someone else. Now, if I may make the point, first of all, that as we were at pains to point out in our written submissions, the extradition function of complying with international obligations is a quintessential executive function. We have pointed you to authorities in which it has been, the importance of that function has been highlighted because it involves the task of ensuring that Guyana's international obligations to its treaty partners are complied with, that Guyana ensures that our treaty partners are acting in good faith and making their requests in good faith and so on. In other words, there is a high political element involved in acceding to a request. And as I will point out to you when I take you to the provisions of the Fugitive Offenders Act, even in deciding...
Mr. Mendes, you must mean commencing the extradition process.
As well,
because you cannot have an extradition process without the judicial determination on it. Is that correct?
No, the extradition process commences with the issuance of the ATP.
Exactly, eating the ATP. That's what you mean. Okay.
I mean that, but as well, the issuance of the eventual order of extradition, if you get to that stage after the judicial process, is also an exercise of political will.
After the magistrate has said, go ahead.
That's correct. Even if the magistrate says go ahead, even if the High Court says go ahead, the Court of Appeal, the CCJ, the minister still has the discretion not to order extradition.
Yeah, but if the courts say no to the extradition, that's the end of it.
That's the end of it, yes, of course.
Thank you.
The minister has no discretion if the court says that, for example, that there's no extradition crime established. But the point I'm making is that the minister has a discretion at the ATP stage as well, because when I take you to section 12.1, you will see that it says that the minister may issue an authority to proceed in Form 1, which suggests that the minister has a discretion not to issue it. Because it could happen, I'm not suggesting that in this case, it was something that was a candidate for other consideration, but it could happen that a request is made by a treaty territory, but for some reason the government of Guyana is of the view that this request should not be entertained at all because of whatever else may be taking place on the international stage between Guyana and that particular country. There may be many other political reasons why Guyana may decide not to accede to a extradition request at all, and therefore, in the minister's discretion, decide not to issue it. My point is,
I know this is not central at all to the discussion, but if the minister is satisfied that the conditions set out in the statute have been fulfilled, would the minister not come under an international obligation to issue the ATP? And if that issuance does not take place, will that not represent a potential breach of the treaty arrangements? But are you then saying that this court would not have jurisdiction to inquire into that breach?
That would be not for this court, but the point is that would exist at the international law level. But the point is that the fact that the legislation gives the minister the discretion whether to issue the authority to proceed indicates that maybe exceptionally that the minister could decide not to issue it at all. My point is that there is a political element in both the issuance of the ATP and in the issuance of the ultimate order for extradition. And this is why the legislature has made the choice of vesting in the minister the power to exercise the extradition functions, and not, for example, in the Director of Public Prosecutions, and not, for example, in the Permanent Secretary of the Ministry of Foreign Affairs or some other functionary of that sort. It clearly is important and is consistent with extradition law and consistent with the need to ensure that we comply with our international obligations, that it is a minister, a member of the executive, a member of the cabinet that is vested with the extradition functions.
But you say there's an overlap between that argument and the issue of delegation?
That is correct. So the point is that whereas my learned friend is urging upon you that the minister could have exercised the power under the Interpretation and General Clauses Act to delegate to a public officer, respectfully, that would run contrary to the intention of the Fugitive Offenders Act. It runs contrary to the intention of the legislature investing that power in a minister, because that
Mr.
decision.
Mendes, can we just pause a little bit?
Certainly.
So let's suppose you are right on that. Is it then part of your argument that the only minister is the Minister of Home Affairs? Or is it that, oh, so I'm sort of adopting your not conceded, but for argument's sake, acceptance that there is infection through bias. Let's
Yes.
suppose that is the status quo.
Yes.
And let us take your point that under 27 is not applicable, and the intention is, because of everything you've just said, the political executive function, it must be a minister. If, and I know you're not conceding this, if the Minister of Home Affairs was in fact clearly infected by bias, actual or otherwise, what would be the result, given your construction of 12, i.e. that it is only the minister who could exercise this power?
If it is only the minister, then the minister has no choice but to exercise it. And the fact that the minister is apparently biased is of no moment.
All right. Suppose the minister was actually biased. Suppose there is, because you could have both, you could have actual bias too. Suppose there was evidence, clear evidence of the minister having some sort of pecuniary or other interest in the outcome, however that evidence came out. Would your position be the same?
Okay, if I may use this example, let us assume that the person who the United States wishes to have extradited is the minister's child. In those circumstances, obviously, all of the arguments that we have presented as to the modification of the rule against bias would be very difficult to make. So what ought to happen in these circumstances is that the president ought to relieve the minister of the extradition functions temporarily and vest that portfolio in another minister. And that
way you preserve the impartiality for the decision maker, because okay, so that I understand clearly what you're saying, so that the portfolio remains the determinative consideration as to which minister, but the infection by bias is cured not by delegation to a public officer pursuant to 27, but by the removal of the portfolio from the person affected to another person.
Exactly.
Yeah, no, okay, fair enough. But you will say that is not a delegation then.
If I may, Peter,
sorry.
It does not have to be by the shift in portfolio, but by the appointment of another member of cabinet, another minister, to act as Minister of Home Affairs for a limited period, etc., to execute those functions. So the portfolio remains with the Ministry of Home Affairs, but a different person is acting as the minister. Thank you.
Yes, Your Honor.
So Mr. Mendes, if I may, just quickly. So in Froome, where the applicants submitted in Froome, it was delegated to a lawyer. And as I understand you, you're saying that under the FOA in Guyana, that would be contrary to the scheme of the legislation. In Canada, that's because of a different legislative scheme. Is that it?
I don't know the answer to that question because I don't know the legislative scheme that was being operated in that case. But what I am saying is that the legislative choice in Guyana is clearly that the power be exercised by a minister, and I've given the reason why I think that is proper legislative policy, and therefore why it is that it would be an improper exercise of the power of delegation to delegate it to a public officer, because that public officer would not is not a member of the executive and therefore would not be able to exercise the political judgment that would be necessary in those circumstances. But the point that I'm making is that even though in the case that we have imagined, that is to say that the minister is being called upon to issue an ATP in relation to her son or her daughter, as the case may be, even though you could imagine that you solve the problem in either of the ways just suggested, in this case, that's not a solution, because the basis of the applicant's complaint is that any member of the executive would be infected. That's the argument. The argument is that anybody would be, of course, as they say, beholden to the president and the vice president and the attorney general who have made all these statements. So there could be no minister who could be appointed, who would be now a member of the government, who would not be subject to the same complaint. And we respectfully submit that, having regard to the fact that nothing is alleged against this minister, except that she ridiculed the second applicant, not even the first. Nothing is said about her in relation to the first applicant. The only complaint is made in relation to the second applicant, and it is about what one would expect would happen in any political campaign. Respectfully, according to their own case, they ought not to get any relief, in other words, even if bias is established in relation to this particular minister. And that's our application of this.
That's the easy case.
That's
Now,
the easy case.
Yes, what if, again, hypothetically, one of the three top officials against whom allegations of, shall we say, intemperate statements were made, was in fact the Minister of Home Affairs? How would you approach that issue?
That would be, that is to say, as to whether again, don't forget, Your Honor, at this stage of my argument, the assumption is that bias is established.
Yes, no. We understand you fully. And obviously, you do not concede that, right?
But on the assumption that bias is established, then the two solutions that we have just found cannot be
used. Exactly.
Can't be used at all. Right. So that you're stuck with the minister to whom the extradition portfolio is assigned, exercising the power, because that is the only minister, or put it this way, it is only ministers to whom the extradition portfolio is assigned who can exercise the power, but all of them are compromised in accordance with the argument.
So ex hypothesi then, how is that problem to be resolved? Because on the hypothesis, which none of us, of course, is asserting, that there was this systemic bias, how is that to be resolved consistent with the rule of law?
Consistent with the rule of law, since seeing that somebody has to make the decision, and the only persons who can make that decision by law are compromised, then the decision just simply has to be made. In other words, Your Honor, we have to hold our nose and proceed.
I thought you'd have said that the court ultimately could superintend whether the conditions would have been satisfied.
But that would be done in any event.
Right.
So we're just dealing with the problem of bias by itself. But the point is, and I'll come on to that when I'm dealing with the nature of the function that is being exercised and interrogating exactly the extent to which the rule of bias can apply. But the fact of the matter is that the merits of the complaint, that is to say, whether the extradition is actually unlawful or would not in fact be made, that will be interrogated by the magistrate. That will be interrogated by the High Court and the Court of Appeal and the CCJ. So there's all the protection, the rule of law protections that you're referring to, Your Honor. All of that will be canvassed before judicial officers.
So that's why you contend then that the issue of bias and the litigation of that issue is misplaced in relation to the minister.
That's
because
correct.
even in a situation where you can see that there was in fact bias, that would not halt the proceedings. They will proceed to the second stage of the judicial hearing. Do I have you right?
Yes, but and of course there are many points that I make. There's also a great degree of artificiality about this complaint because my learned friends have not yet said, despite the fact that the court this morning has asked on a number of occasions, they have not said what is unlawful about the extradition. They have not said what factor are they pointing to which would suggest that there would not be an extradition.
They're pointing to the fact allegedly of bias. And what they are saying, if I understand it correctly, is that the mere presence of bias is sufficient in and of itself to nullify the process undertaken by the minister who is infected by bias.
Yes, Your Honor, but I was responding to your point that the substantive issues of legality will be addressed at the judicial phase. And I'm saying that even as we now stand, even though obviously that is so, that any question of unlawfulness can be addressed at the judicial phase, they have not, despite questions from the court, identified any particular issue that the minister may have decided differently. In other words, they have not suggested, for example, that the extradition is being pursued for political reasons, or that any of the applicants will be prejudiced on the basis of their race or religion or politics. They haven't suggested that. Or that there is no specialty arrangement, or that this is not an extradition crime. They have not made these submissions at all.
Mr.
Nothing
Mendes,
has been suggested.
we get you on that. I want to return you to a point you made earlier. You said that extradition, or rather the ATP, is quintessentially an executive act, and it needs to be seen to have been done by a minister. Question to you would be, minister goes on holiday, the minister is sick. Who acts for the minister in the meantime?
Well, there would be provisions under the Constitution for other persons acting for the minister. So in the meantime, somebody would have been appointed by the president to act in place of the minister.
It need not be another minister. It can be a permanent secretary. Is that correct?
I can't remember the exact. The Constitution does speak to who can act for a minister. I don't recall exactly at the moment.
I think off the top of my head, Mr. Mendes, it has to be another minister.
Fair enough.
It might be a parliamentary secretary.
So we're not. Let's not get lost on that. What I'm getting at is this: you say that the matter requires political judgment, and it is only the minister that can bring that. My question is, why is it that a permanent secretary cannot bring political judgments to bear on a question like this? A permanent secretary.
I think your answer, Mr. Mendes, will be because the permanent secretary will not sit in cabinet and will not be answerable, and the collective responsibility will not appertain to what the permanent secretary does.
That's precisely what I was going to say. I was going to say the permanent secretary is not a member of cabinet, and therefore will not be, first of all, would not be aware of, or not, might be aware of, but certainly not sitting in cabinet and participating in any discussions concerning government policy or the current relationship between Guyana and the requesting state. And
so that submission must mean that section 27 6 sub 2 and section 27 of the Interpretation General Clauses Act cannot operate where the minister is the person pointed to in a piece of legislation to perform an act. Do you go that far?
No, I don't go that far, but what I'm saying is that just like every statutory power, it is subject to public law constraints. And whereas in relation to some other statutory powers, say the power to issue licenses, there would not necessarily be any constraint on the minister in delegating that power, say, to a permanent secretary. In the area of extradition and international relations, there is the constraint I am respectfully submitting on the exercise of the minister's power to delegate that power to someone who is not sitting in cabinet and therefore is not accountable to Parliament. And this is why I'm saying ultimately, therefore, on the applicant's submission, all ministers are compromised, and therefore there's no minister who can exercise the extradition function in the context where it would be not appropriate to delegate the extradition functions to somebody outside of the executive government.
Mr. Mendes,
that would be my.
I understand that very clearly. I just want to get something, maybe it's sort of like to summarize what I think I hear you saying. Conceptually then, barring everybody being infected, that argument,
yes,
if there is sufficient bias in the relevant minister,
yes,
then the appropriate thing to do to protect the rule of law would be to take that portfolio and pass it on, whether to another minister or appoint a person to act as our brother has suggested. Would you agree that in that hypothetical, that would have been the due process to balance the international obligations, keep it with an executive member, purify the system by removing the infected person, and you achieve that by moving it so that conceptually bias remains a relevant consideration that can be cured through the mechanism that you have proposed. Is that a fair summary of what you've said?
Absolutely, of course, but in case my learned friends jump on what they perceive to be a concession, I'm saying the assumption is.
I know, I'm very clear.
Bias applies.
I am very clear that you have not conceded that. I'm not for a moment trying to put words in your mouth, please.
No, I know.
I am. That's why I said on the hypothetical. I'm very clear what your position is on that. I'm just trying to understand it. Thank you.
Yes, that would be the normal. That would be the normal consequence of a finding of bias.
Yeah.
That would not that somebody else who is not infected by bias would exercise the statutory function.
But in a case, as you have said before, where everybody is infected, on the hypothesis, of course, then the minister has to do what the minister has to do. In that latter case, is the question of bias reviewable by the court, or clearly it follows from what you have just said that that is not a question for the review of the court?
Well, as long as you find that there is necessity, necessity doesn't prevent the court from reviewing and making a determination as to whether the apparent bias test has been satisfied. What it means is that even if you find that it is satisfied, there is nothing that you can do because the law requires that this.
So what's the point of deciding if you can't do anything about it?
Well, the point is that
equity doesn't act in vain.
The point is, Your Honor, you may decide because the doctrine of necessity applies. You may decide, well, I won't waste my time to make a determination on bias because in any event it would make no difference.
Right.
But I'm just saying, I'm answering your question.
No,
whether
sorry,
you
I
can't
wanted
decide.
to follow up with that. Okay, so in a sense, then the reviewability of the bias question might not bear fruit, may not be useful. What about the provision in 12.2, where the minister must be satisfied that certain things are done? Is that judicially reviewable?
Okay, you mean, Your Honor, if it
Section
is,
12.2, which says that the ATP must not be given unless conditions precedent are fulfilled. Is that something that can be reviewed by the court?
well, if I may repeat exactly what it is that Section 12.2 says. It says the minister shall not issue an authority to proceed if it appears to him that an order for extradition of the person concerned could not lawfully be made. Now, let us assume that there is evidence that it did appear to the minister that an order for extradition could not lawfully be made. Let us assume that there is evidence, however that evidence comes about, but the minister said, you know something, this extradition cannot lawfully be made because Section 8.2 or 3 or whatever of the Act is not satisfied. And it appears to me that it is not satisfied, but nevertheless, I'm going to issue the ATP. In those circumstances, the minister would be acting contrary to Section 12.2 because Section 12.2 prohibits the issue of the ATP if it appears to the minister, etc., etc. So yes, obviously the issue of the ATP in those circumstances would be reviewable. The more difficult question is whether, when the minister says, well, it does not appear to me that an order could not lawfully be made, but then you challenge it and evidence is produced that, well, one of these provisions of Section 8 was not satisfied because there is no treaty or there is no arrangement and so on. In other words, you're saying that it ought to have appeared to the minister, and therefore the minister made an irrational decision that it did not appear to her.
Mr. Mendez, isn't that the scenario? Isn't that the matrix in 1 or 2? Isn't that the 1 or 2 matrix, basically? No, it wasn't raised that way, but in effect, that's the 1 or 2 matrix, right?
In effect, so, because it was the way the Act, the Trinidad and Tobago Act is framed, the minister had to be satisfied that there was an arrangement in place before it's in.
So on the 12.2 point, then the minister has to exercise a deliberate judgment, has to consider the relevant factors, including, of course, Section 12. Now, where the minister decides on this over a 2-hour period, would you say that that represents sort of deliberate consideration of all the things the minister ought to consider before deciding on the ATP?
Well, Your Honor, I am not aware of evidence that the minister decided this over a 2. I saw that in my learned friend's submissions. I have not seen it in any of the evidence that is before the court. But
I'm not sure it was rebutted that the request for the application, the request for the extradition came in on somewhere in October. And then a few hours later, the ATP was granted. Do you dispute that?
Your Honor, what I'm saying is that that appears in my learned friend's submissions. It does not appear in the evidence that is before the court, unless I'm mistaken and I have missed it somewhere. But in any event, Your Honors, what the minister did in her affidavit is to set out the process that she followed. Now, if it is now being said, well, she could not have followed that process because it only took her 2 hours, that is not the basis of challenge. The grounds of challenge is not that the minister did not properly perform her function under Section 2. The only ground of challenge is bias. So that it is
but
not...
even so, would your submissions on waiver be relevant to that point? in the sense that if it was a case that everyone was anticipating this extradition request to be made and counsel for the applicants had been communicating with the minister saying, we see this may be coming, when it comes, we will cooperate and all that stuff. I'm asking a question here, maybe I got it wrong, but would that be something to take into account as to whether the speed at which ATP was issued was unduly hasty?
Well, that would not affect the argument on waiver. That is
No,
an
no,
argument.
not that it affect the argument on waiver, but whether the argument on waiver which you made could have addressed that point.
Well, it wouldn't. Well, I don't think so, because if the argument, if the ground of challenge is that the minister did not in fact exercise her functions under Section 12(2), because the time was too short to do so, that's not a bias argument. That is an argument that the minister did not exercise her functions at all. And of course, that is a classic ground of public law challenge. You are required to exercise a discretion and you just simply didn't do it. But that doesn't, you can't, I'm sorry, Honor, that argument is not counteracted by waiver, because they're not waiving her exercising her power. They are waiving the challenge on the ground of bias.
Yeah, I understand that. That's a different question, but I'll leave it.
But the very short period of time, I suspect that the other side would argue, support their argument that there was some degree of bias there.
Well, Your Honor, if that
made,
was...
In other words, the minister made her mind up, a long time ago to let the ATP be issued.
Well, the question was, the question was whether the conduct of the applicants might have played into the minister making up her mind that this is something that could go quickly, because the appellants may have signaled ahead of time that we're expecting this, so if it comes, you make it, we're ready to deal with it. Anyway, but we can leave it at that.
Your Honors, my point is a fundamental one, that it was not pleaded that the minister did not or could not have exercised a function properly under Section 12(2). If that had been an allegation, if it had been said that you could not have been done so because of the short period of time, then we would have taken instructions on that, and maybe the answer would have been, well, just as the appellants were aware that a request was in the making and so on, I began to prepare myself for a request because I knew it was coming.
I'm not sure about the strength of that argument at all, Mr. Mendes, because you can only respond once the request has come in. Would you know what the offenses are, for example, that the request related to?
Well, Your Honors, all I am saying is that we can't interrogate this issue at all.
No, well,
and it would not be proper for the court to interrogate the question of the failure of the minister to exercise the functions because of the 2-hour the 2-hour window, because that was not pleaded.
Fair enough.
And I'm saying, and I'm emphasizing the importance of pleadings, because I'm speculating, obviously, because I do not know what would have happened if it had been pleaded, but I'm speculating that the minister may have said that I was readying myself for the request. And to answer your point,
as you say, maybe we should be cautious about going down that road. I think our sister, Justice Anani, who wanted to ask a question, please.
Thank you, President. Mr. Mendes, if you could go back to the nature of the statutory function under Section 12.
Yes, I'm coming to that.
I'm very interested in that because I think all parties have agreed that that's quite important to assessing what the requirements of procedural fairness would be in the circumstances of this case.
Yes.
The applicants have argued that the nature of the function of the minister is adjudicative. And they indicated that even though this is clearly not an inter partes setting, it could still be an adjudicative function. Now, there has been a lot of emphasis on section 12.2.
Yes.
Which places a very specific duty on the minister, but in particular circumstances. That's if it appears to the minister that an order for the extradition of the person concerned could not lawfully made or would not in fact be made. In those circumstances, the minister has a duty not to issue the ATP. My question is this: is there a responsibility, a duty on the minister once a request is received to make any kind of positive determination that an extradition order can lawfully be made, and would in fact be lawfully made? Is that a responsibility that section 12 places? I'm asking this question because I see quite a distinct difference between a duty not to issue the order if certain information is before you, as opposed to a positive duty once you receive a request to make a certain type of determination. I have a follow-up question. Thanks. Once you answer that, please.
Yes, Your Honor. My answer, the short answer is yes. There is no positive duty to make a finding of lawfulness, or that an extradition order would be made. And in fact, that is the case that we have put forward in our written submissions. But it requires both an examination of the language that is used in section 12.2, but it also requires interrogation of the type of the circumstances in which extradition might be unlawful, and therefore an interrogation of what process the Minister of Home Affairs would be expected to follow in complying with section 12.2. So I'm indicating that I have to answer the question in two stages. First, by looking at the language, and then by imagining the types of situation that might appear for the minister. So the section says the minister shall not issue an authority to proceed, and therefore that's the duty. Do not do it. When, and it answers that question, if it appears to the minister that an order for extradition could not lawfully be made or would not in fact be made. So that the minister has to ask the question of herself, does it appear to me that an order for the extradition of the person concerned could not lawfully be made or would not in fact be made? Now the minister could say, presumably, well, I'm not aware of anything that makes it appear to me that it's unlawful, and that's it. And you sign off, you sign the ATP. Nobody has presented anything to me. And then the complaint might be, well, you just can't sit down and say, well, it doesn't appear to me, and therefore I am going to issue it. The prohibition is not there. The valid complaint would be made. Well, you have to do some sort of inquiry. You can't just sit down on your desk and say, well, nothing has come to me to make any of these suggestions, and therefore I will do nothing. And therefore there's no prohibition, I will proceed. So it does require some sort of inquiry by the minister as to whether there are any circumstances presented by the documents that are before her, which might make it appear to her that the extradition could not lawfully be made. So that's why I say, let's look at the examples now.
Before, just pause, a nuance. Yes. You said they must look, so that you say it does require some sort of inquiry by the minister.
Yes.
But then you qualify that by saying the minister must look at the documents placed before them.
Well, that's the first thing.
Before you move on, is it that is a limitation of the inquiry to look at the documents presented?
Not necessarily. It all depends on the case.
No, but no, fair enough. I just wanted to be clear because you qualified the statement by saying by looking at the documents. I just want to be very clear because I assume you will tell us what is the sort of standard for the quote unquote sort of inquiry.
Yes, but the point is, Your Honor, that it all depends upon the case. And I have to remind Your Honors that this exercise is taking place in circumstances where either a provisional warrant has already been issued before the request is made, and somebody is therefore in custody, maybe on bail, but certainly in custody, and therefore the minister has to decide. You can't take your time about it. You have to be mindful of the fact that somebody is in custody and a request has not yet been made, or an ATP issued, or the exercise is being performed at a point in time where there is no provisional warrant, but there may be concern that the person might hear about the request and flee Guyana and put themselves beyond extradition. So I'm saying that there is some constraints of time as far as the exercise of this power. So that will obviously impact upon the degree of investigation that the legislature would expect the minister to engage in. So against that backdrop, the first section 8.1 says, a person shall not be extradited under this act from Guyana to a Commonwealth or territory, or could be committed to custody and so on, if it appears to the minister, to the magistrate, to the High Court, to the Court of Appeal, and so on. A, the offense of which the person is accused or has been convicted is an offense of a political character. Now, that obviously means that if for the minister to do this, to say, does it appear to me that the extradition would be unlawful? You're going to have to look at the offense. And looking at the offense, which would be in the documents that the minister is provided with, because there's a requirement to provide particulars, etc., the minister would look at that and say, well, does that appear to me to be an offense of a political character? So the minister must ask that question. Then the next one, the request for extradition.
So I think we're following the logic of what you're saying.
Yes.
My sister said she had a follow-up question. I don't know if she still has it.
Thank you, President. What I've been trying to assess is whether the kind of examination which the applicants have argued is required under Section 12 actually arises given the nature of the responsibility placed on the minister. So, for instance, the applicants have argued that when deciding whether an ATP ought to be issued, a minister has to look at evidentiary compliance or sufficiency. The applicants have argued, for instance, that the minister has to make an assessment as to whether there would be any discretionary bars against unjust or oppressive extradition, and the Catroni factors. What I'm just trying to make sense of is whether under Section 12, whenever a request comes in, the minister is required to make a positive determination about all of these matters.
Yes,
that's a very different kind of responsibility than.
Yes, I know. I'm submitting no, because what I'm doing that by way of the examples. When the minister says, I looked at this and it does not appear to me that the offense is of a political character, the minister does not determine that the offense is not of a political character. And similar, when it says the request for extradition is in fact made for the purpose of prosecuting or punishing him on account of his race, tribe, sex, religion, and so on, the minister would be looking at the material and saying, it does not appear to me that that is the actual purpose of it, but it does not mean that she's saying that is not the purpose, because later on evidence may be presented by the applicant when they have the opportunity before the magistrate or the High Court of adducing evidence that this is really for the purpose of prosecuting me because of my race, nationality, or political opinions, and so on and so on.
So, Mr. Mendes, my last question on this, just to be clear based on your submissions, is that can bias arise if the nature of the statutory function is not adjudicative in character? It's a basic question I'm asking.
Yes, and that is basically our submission. Our submission is that accept the general proposition as we must, because that this is what the authorities say, that there's an obligation of fairness attaching to every statutory power, every statutory duty. The question is, what is the content of fairness? And that would depend upon the nature of the function and the statutory and factual context in which the power is to be exercised. And one of the factors which the authorities have indicate, and the learned friends cannot dispute it, there are so many authorities that say it, one of the important questions is whether you are adjudicating on anything. And we're respectfully saying that the minister does not adjudicate in the sense of make a determination of any of these things. All the minister is saying is, I have done the examination that I am duty bound to do under Section 2 to determine whether I am prohibited from issuing the ATP. And all I am able to say at this stage, and in fact, that when you look at the minister's evidence, that's what she says, all I am able to do at this stage is say, nothing has come before me which would suggest that any of these prohibitions apply. And as a matter of fact, she says, maybe that evidence might be presented later on, but it has not yet been presented to me. So I am unable to say that it appears to me that it would be unlawful. And to the second part of your question, the Section 8 would address the question whether it appears to her that it could not lawfully be made. But the second question is whether it would not in fact be made, and that requires the minister to engage in some speculation as to whether the High Court, in exercising its power under Section 17, that is to say, to decide, because under Section 17(2), the High Court may order a person to be discharged if the court is satisfied by reason of the trivial nature, etc., and that would include the Cotroni principles, that having regard to all of the circumstances would be unjust or oppressive to extradite him. So it is possible for the minister to say, well, it appears to me that it could not lawfully be made, it would not be made, as opposed to could not lawfully made, that it would not be made because there are these factors that are pointing so compellingly in the direction of it being unjust and oppressive to extradite that it appears to me that it would not lawfully be made. One of those possibly later on down the road is the Cotroni factors, but the Cotroni factors require a lot of evidence to be put before the court. And again, the ministers pointed this out. A lot of evidence to be put before the court concerning who started the investigation.
Mr. Mendez, I think so, but
thank you very much.
I think part of what you have explained is, and again, I'm seeking your feedback as to whether my understanding of what you're saying is fair. That is my understanding. This is not a rubber stamping of or ticking of boxes of receipt of documentation. Even though you frame it in the negative, what is required of the minister goes beyond that. You say it is not adjudicative. Fine. I'm not on the labeling for the moment. I'm on the actual exercise of what has to be done. More is involved than simply rubber stamping. This is not a clerical function the minister is exercising. This is an executive, discretionary decision within the limitations of what you have described. Is that a fair summary?
Sorry, before you answer, I invite you to answer, but could you, in answering, also wrap up? You've gone well over the hour assigned. So having answered my brother, if there's any specific point you need to make beyond what's in your written submissions, please do, and we're going to move on. Thanks.
Thank you very much, Your Honor. Could I claim some extra time for injury? Injury time?
You have been given extra time.
I'm just my learned friends have been given a lot of injury time because there's an important point that I wanted to make.
Please.
I'll answer Justice Jamada's point very briefly. I I'm saying that there's no determination that is made by the minister. And in that sense, there is no adjudication. But I am not saying that the minister has nothing to do. Obviously, the minister has to ask the question, does it appear to me that it could not lawfully be made, and that therefore requires some sort of examination. I'm just saying that in the absence of the applicant, that cannot be or cannot approximate what would happen, for example, when you go before the magistrate and the magistrate has to answer the same questions, or when you go before the High Court and the High Court has to answer the same question, and therefore that must impact upon the content of the rule against bias. But most importantly, and this is the point that we make, and if I may spend the remaining time just dealing with this point, Mr. President, most importantly, is the statutory context in which this decision is being made. And the most important part of this, which I've spent a lot of time in our written submissions emphasizing, is that the legislature has decided that it is the minister assigned the extradition portfolio who is to make these decisions. And the minister, therefore, the legislature must have anticipated that the minister at some point in time will have to be entertaining requests for extradition, both in relation to political opponents as well as political friends. And this is an important part of it, because if a political friend comes before the minister, the United States or whichever country is seeking the extradition of a political friend, the same accusation of bias can be made. In other words, that the ministers, there's a real possibility that the minister may unfavorably or favorably view the case of this particular person because they're a political friend and the opposite in relation to a political foe. My point is that the legislature must have contemplated that the minister, being a political appointee, would have to face political foes or political friends. And it would undermine the legislative choice that is made if you were to say, well, you have to step down, and all ministers will of course be excluded on this argument, and somebody else would have to be appointed, when the legislature must have anticipated these possibilities. And this is why we say in circumstances like this, the test is whether you had an open mind and whether you actually performed your function in a genuine way. That would be the test in these circumstances.
But Mr. Mendes, just quickly to test the hypothetical. It's the minister and the minister's child. If the minister's child is also whatever, and the application to extradite goes to the minister's child.
Yes.
Won't the same principle that we agreed on earlier apply?
No,
you talk about opponent and friends.
No, Your Honor, because
why
again,
not?
When you appoint a minister, you know that the minister has political friends. You know that the minister will have run a political campaign. You know the minister may have said things that are not nice about political opponents. And in circumstances where your political opponents are accused of crimes, and it is public, as in this case.
My hypothetical is where the political friend is a child.
Yes, but Your Honor, I'm saying that when the legislature is making the legislative choice to give the power to the minister, it would not have in contemplation the unusual circumstance of the minister's child being the subject of a request. But the legislature would have in mind the usual circumstance of the minister having political opponents that the minister may have said, although that's not the accusation in this case, may have said very unkind things about the political opponents, may even have alerted the electorate to the fact that there were accusations of criminal activity against your opponent and so on. Those are the things that the legislature would expect the minister.
And do
would
you
have
think there
encountered
is
and
a
so on.
threat? Do you think there's a threshold apart from general accusations of criminality and so on? If the allegation was specifically that I know that this third party state intends to extradite, and when that comes, I am going to grant it. So okay, so you have a corpus of general, whatever. If it is specific now to pre-knowledge or pre-statements about the possibility of extradition and statements that say when that comes, I am going to extradite because these people are A, B, C, D, E, F, G. Does that make a difference in this this construct you have about the legislature presumed both political opponents and friends, and so even where the political opponent or friend, whoever, now the evidence is specifically in relation to the extradition process. Does that make a difference?
Well, again, that is catered for in the test that we say should apply, whether you have an open mind and whether you are performing your functions genuinely. So the question would be whether the minister had an open mind.
An open mind there means what? What does that open mind mean? If you pre-stated that I hear the extradition and if it comes, I'm going to grant it, is that an open mind?
But if the minister had said that?
Yes.
Well, first of all, again, the question whether you have an open mind is always fact specific, as you know. And just simply because you said something that suggested that this is how it would happen, the authorities are replete with circumstances in which the court said, even though you expressed yourself in this way, that does not mean that you have an open mind. But if the facts are such that it establishes very clearly that you do not have an open mind, that come what may, no matter what is presented to me, I am going to exercise my power in this way, then that is not what is in contemplation by the legislature.
Is that, Mr. Mendes, is that the test in Porter and McGill?
No, it is not, but it's the test that it is the test that we are respectfully submitting that would be the appropriate test to be applied in the circumstances of this case. Justice Jamada, if I may give you an example.
Sorry, it's going to be a very short example, please. We have well past injury time.
Your Honor, would it be okay if I steal some of the Honorable Attorney General's time if he gives me? I just need to complete this point. It's very important to my case.
Honorable Attorney General?
If he can give me 15 minutes, if he doesn't mind.
Yes, I'll give you 15.
You'll see it? Okay, good.
I'm grateful. I'm very grateful. If I may, Justice Jam, if I give this example, let us assume that just like the minister having to deal with a request in relation to her son, let us assume the particular political opponent is somebody in respect of which there is personal circumstances that leads to hostility or enmity or whatever. Let's assume that they are in some other personal dispute. It could be financial dispute, it could be personal, romantic, something of that sort. I don't want to be too creative, but just in other words, this is going beyond, it is a dispute that goes beyond what you would normally expect of political opponents. So this is personal between the minister and this particular person. Then that is different. That is not within the contemplation of the legislature.
And
what's
in
the
that
consequence of that?
context, what would be your remedy?
What would the consequence of that be?
Yeah. What would
In those circumstances, the consequence is, as we have suggested before, the president appointing somebody to act in the stead of the minister, or assigning the responsibility temporarily to somebody else.
And if the president does not do that, what then?
Then you're back in the situation where there'll be the normal remedies that are available to the court. If waiver applies, of course, it doesn't apply. If necessity applies, of course.
Including quashing the ATP.
including the quashing of the ATP.
Okay.
Those are the normal
but,
remedies.
but Mr. Mendez, it will never be an abuse of process under GR to bring the challenge then. The takeaway as you come to the end seems to me to be subject to proofs and standards. You can bring a challenge on bias. At this stage, whether it succeeds or not is a question of standards, that is which test you apply, the Porter and McGill or the open mind test, and the proofs, the evidence. Is there any evidence that this minister did or that what the AG did that impacted could have any significance? But conceptually, you could bring it.
Well, Your Honor, I'm a bit surprised that I'm being asked that question because we have never challenged the jurisdiction of the court. And as a matter of fact, in our reply to my learned friends, we have said that we do not say that the decision is not subject to judicial review. The question is on what grounds?
Yeah.
It is
Point
it
taken.
is a very serious.
I think I'm influenced a little bit more by what I may have read in the Court of Appeal decision, but in fairness to you, you are right. So
Yes.
no need to respond any further. Yeah.
Yes, so just to make the point that I'm making about the legislative intention and undermining the legislature, if I may draw your attention to the decision of the divisional court in the United Kingdom. This is the Goodyear Project and Runnymede Trust against the Prime Minister. It's a 2022 decision, and it's a decision of Justice of Appeal Singh, who I think sits on the Privy Council from time to time. And I'm looking at page, electronic page number 4885. And he said in relation to Justice Sedley's decision in Kirkstall, which is one of the cases that my learned friends relied on, he says, while he's referring to Justice Sedley, while he rejected any hard and fast distinction between administrative decision-making and either judicial or quasi-judicial processes, he recognized that any attempt to apply the principles of apparent bias outside of the context of judicial or quasi-judicial decision-making had to be sensitive to context. Justice Sedley accepted that when considering a planning decision, it was important to recognize that decision makers such as elected councillors or members of an urban development corporation might have legitimate prior interests. For example, they will come to their positions, elected or appointed, because of local knowledge. The principles of apparent bias could only operate in this context to the extent that any prior interest could be identified as legitimate. And a similar statement, and very important statement, is made by Justice Supinka in the Supreme Court of Canada decision of Old St. Boniface against Winnipeg, and I'm referring to electronic page number 873, where the court said, is therefore, again dealing with elected councillors, it is therefore necessary to examine all the factors under which a committee of council operates. I start with the most significant fact that the statute provides for a hearing before a committee of council of members. There is nothing in the legislation to indicate that they are to act in a capacity other than that of municipal councillors. In this regard, I must assume that the legislature was aware that in this capacity, the members of council will have fought an election in which the matter upon which they are called upon to decide may have been debated, and on which the would-be councillors may have taken a stand, some pro and some con. Indeed, the election of a particular councillor may have depended on the position taken. Furthermore, with respect to the enactment of zoning bylaws and amendments to zoning bylaws, it's well known that numerous committees are involved at which members of council are expected to vote before being called upon to hear representatives.
Mr. Mendez, I don't want to interrupt you because you're reading from the case, but we know those cases, and those cases in the category of policy decisions around planning, economic decisions, and so on, where what you're saying is before you have to make a decision, you would have a position, you would have a pre-decision. I'm in favor of building the road. That's what I campaigned on. Then the decision comes before me because I'm elected. That's not bias to vitiate it if I have an open mind. So the open mind, genuine decision-making cases fall in that bucket. I think that is so. I don't think you need to press that point. I think the point before us is that transferable where you have a rights-based challenge? That is what is before us. isn't it?
If I may just read this last part of it.
Sure.
In the course of this process, a counselor can and often does take a stand either for or against the development. This degree of prejudgment would run afoul of the ordinary rule which disqualifies a decision maker on the basis of a reasonable apprehension of bias. Accordingly, it could not have been intended by the legislature that this rule apply to members of council with the same force as in the case of other tribunals whose character and functions more closely resemble those of the court. And I will direct your attention as well, I'm not going to read it because of time, to Hot Holdings against Creasy, electronic page 1074, and the case of Minister of Immigration against GIA. This is at electronic page 1010. All of them make the point, and this is the important point, Your Honor, that in determining whether the extent to which the rule of bias applies, you have to take into account the fact that the legislature has vested powers in elected persons, ministers, elected persons. And I'm saying in this particular context, you have to take into account that the legislature is vested in a minister who will have political opponents and therefore who may be called upon to entertain requests for extradition in relation to political opponents. And therefore, in relation to those political opponents, you cannot say, well, you are infected by bias because you will benefit if this person is embarrassed by the fact that they have to face an extradition request, have to go through extradition proceedings, and possibly be subject to a committal by the magistrate and so on. I'm saying that in those, you have to take that into account, and it's very important in deciding the extent to which the rule of bias applies in this particular case. I don't know how much of the 15 minutes that I stole from the Honorable Attorney General I still have.
6 minutes.
6, okay, that's great. So to answer Your Honor, Justice Jamada, I'm saying that—
Mr. Mendes, 6 minutes is
Yes,
a lot of time in certain circumstances, but not in others. One thing Justice Jamada was getting at, which I'm interested, yes, Justice Studley did recognize the political exception, and Sopica does as well.
Yes.
But do we see that there's a distinguishing element in circumstances where we are not talking about policy positions taken by governments or government ministers, but we are talking about ad hominem circumstances in which the allegation is that members of the government specifically said stuff about somebody. So it's a dominant situation rather than I campaigned on a platform or manifesto or doing X, and the decision I'm taking comes within that ballpark. But we're dealing here with ad hominem situations of specific individuals, and they are saying they are targeted.
Well, Your Honor, this is not said about the minister. The minister has not said anything about the applicants. That is the first thing. What is being said is that the minister belongs to
in a sense. Yes.
Yeah, it belongs to a political coalition, and it is being said that at least the second applicant is a political opponent, not the first. The first is not a holder of any political office. Is her political opponent, and she will benefit from the issuance of the ATP. So I'm saying that we fall into the category of case that the legislature must have had in contemplation in deciding that it is the minister with the extradition functions who will exercise that power. And therefore, for the court to say, well, you cannot exercise the function because this is your political opponent, and therefore there's the well-informed and fair-minded observer would conclude that there's a real possibility that you would not exercise your functions fairly. That would be in effect to amend the legislation. and to provide the category of persons that the minister cannot exercise extradition functions in relation to. And all of those authorities, including the decision of Justice Supingo, although it may have been dealing with counselors following government policy or taking positions that their party may have taken on issues and so on, the principle is the same. What is being said in those cases is that because you hold a position, because you have expressed a particular opinion and taken a position before, there's a reasonable apprehension of bias. They say it is in a different context in this case, but it's the same thing that is being said. You have an interest in the outcome of the issuance of the ATP, and therefore there is apparent bias on your part, which disqualifies you from making the decision. But the effect is the same if it is applied, and that the effect is to undermine the legislative choice that is made to vest that power in the minister. And if I may make the last point, and that is, I rely on our submissions in relation to the automatic disqualification, and I just wanted to draw your attention. I was intending to draw your attention to a lot of the authorities, but we maintain that automatic disqualification does not apply for the reasons given, that it is the ex parte Pinochet case just simply does not apply. But importantly, in the decision of Bovis Homes Limited against New Forest District Council, relied upon by the applicants at electronic page 2508, the court says here, as I read the decision in Pinochet 2, automatic disqualification arising from a non-pecuniary interest is peculiar to those exercising judicial functions, which Councillor Drake was not. We rely on that to say that it could not apply in these circumstances either. And as far, again, if the test of bias, if the Mercer test applies as determined by this court, we respectfully submit that applying that test and taking into the account the fact that the informed and fair-minded observer must be taken to be aware of all of the facts, it means that the well-informed observer must be taken to be aware of the fact that it is not being said that that any of the prohibitions under the Extradition Act apply. In other words, it is not being said that the minister or that a different result was available to the minister. That is very important. That is why it's very important the questions that Your Honors were asking my learned friend before. Are you saying that a different result was possible? Are you saying that there was evidence that they are going to be persecuted because of their race? Are you saying that there was no third country arrangement or no specialty arrangement? Are you saying that it was not an extradition crime? The answer is that they have not been saying that. And it is therefore important to apply the test in those
in that context. Yes.
In that context. And
I think we have you perfectly well, Mr. Mendez, and I do believe you have exhausted the AG's generosity. So I think we will have to stop there.
Okay.
May I inquire, please, of my elders on the bench, Madam Justice Rajnath-Lee and Justice Barrow, whether a break is indicated?
Let us slow there on so that the Attorney General will not feel too.
I will come to him shortly.
Yes.
Not only your elders on the bench, I think it'd be a general question for everyone.
I'm sorry?
So it's not only your elders on the bench.
There are others as well.
I think it may be something to take
Do
a
I get
break.
the sense then that we should break for a few minutes?
I think you do, Mr. President.
Yes.
That's good.
Well, then if you do, you do.
Yes, so we return 12:45, just a short health break, and we'll hear from you, Mr. Attorney General.
Thank you very much.
Thank you very much. Yes.
PPP will take care of you from erection to resurrection. A quick one for you. And the last time I said that, somebody came up to me and said, man, you little bias. Erection is a man thing. What happened to the women? So I got a woman thing for you. And hear me, from the moment she slime up till you get caught up, we gonna take care of you. Thank you. Thank you.
Who's that one? Low lights and hungry bellies.
Oh, Jesus Christ, if cost of living double, I don't know what happened. A pound of sugar is $300 already. Flour, everything gone up. Everything just raising. You gotta get about $40,000 for buy good ration. You gotta get 3 man now. A weekend man, a monthly man, and a fortnight man.
Imagine 18 hours of blackout, and you're telling people progress. Cost of living gone up 100%, yet you give public servant less. Mr. President, listen to the people, search your soul and you will confess. I want you try surviving on the public base, then you're gonna know but stress. Cause I done fed up, you done fed up, he done fed up, she done fed up, we done fed up, the people fed up. You're hiding corruption inside the cup, look how we go set up. The people fed up. They don't drive no fear in the citizen. They may want the people speak out. Freedom of speech done gone inside the gutter. Knock off when you open your mouth. Discrimination in entertainment, and you're talking about one Guyana. When the Ministry of Culture keep the big shows, one set of girls and banner. Cause I done fed up, you done fed up, he done fed up, she done fed up, we done fed up, the people fed up. You're hiding corruption inside the cup, look how we even set up. The people fed up. Every picture you take and promise you make, everything you do is about clouds. When you come into me for I shake your hand, there's nothing to smile about. Corruption inside every sector, but when it comes to them, they send you. Try investigate efficiency, right? Go talk to Baratans too, cause I done fed up, you done fed up, he done fed up, she done fed up, we done fed up, the people fed up. You're hiding corruption inside the cup, look how we even set up. The people fed up. Fed up on the dirty water, low pressure, want scream and tell somebody. Imagine 1500 US, and they're telling me super salary. I done fed up on the unemployment racism and the lie they say one Guyana. Cause when you look with the oil money going, circulate with one set of banner. Cause I done fed up, you done fed up, he done fed up, she done fed up, we done fed up, the people fed up. You're hiding corruption inside the cup, look how we even set up. The people fed up. we a culture keep the big shows. One set of girls and banner. Cause I done fed up, you done fed up, he done fed up, she done fed up, we done fed up, the people fed up. They hiding corruption inside the cup. Look how we evil set up. The people fed up. Every picture you take and promise you make, everything you do is about clouds. Then you come into me for I shake your hand, there's nothing to smile about. Corruption inside every sector, but when it comes to them, they send you. Try investigate efficiency, right? Go talk to Baratans too, cause I done fed up, you done fed up, he done fed up, she done fed up, we done fed up, the people fed up. You're hiding corruption inside the cup, look how we evil set up. The people fed up.
PPP will take care of you from erection to resurrection. A quick one for you. And the last time I said that, somebody came up to me and said, man, you little bias. Erection is a man thing. What happened to the women? So I got a woman thing for you. And hear me, from the moment she slime up till you get caught up, we gonna take care of you. Thank you. Thank you.
Gwendoline, don't do that to me. That is not true love you cherry to me. No, no, no. Darling, I'm begging for some sympathy. On my knees I'm begging, please. I am hurt and badly squeezed. So give me some ease. For you went with Italy, then you gave to Africa. Coming home with Sammy. You gave to Sammy. Look and share all the honey, then you come running home to me. You tell me that you're going for a walk and your family. I know your granny and your mommy and your daddy will be real happy. But checking on the story that you tell to me, my friend, you can believe it was more than free for she telling lies on family. Oh my God, but she went with Sally, then she gave to Africa on the home with Sammy. She gave to Sammy, look at she all you that you come.
Yes, please, President.
Thank you so much. Honorable Attorney General, please.
Thank you very much, Your Honor, and good afternoon. Being afforded the opportunity to back so low down the order has given me a good vantage point, having listened to the erudite discourses that have transpired. And I think, Your Honors, with Your Honor's leave, a good point to begin is to remind Your Honors of what we know as trite and axiomatic principles in relation to extradition law. It is indeed widely classified and labeled as an area of law that is sui generis. It is of a special kind. The ordinary principles of law that applies to the ordinary functions of state, public organizations, public officials do not necessarily apply with the same rigidity, or some may not apply at all. And that is why when we deal with matters that are sui generis, sometimes we have to keep reminding ourselves, because some of the principles which apply are unique and can run counter to our basic understanding of what is fairness, what connotes propriety, etc. Extradition is one of them. It is based upon international law, and it has an unusual intermixture or admixture with domestic law. It involves treaty obligations. It involves comity and reciprocity. It begins with a process that commences by one executive to another, and it ends that way as well. In the interregnum, there is a judicial process, both enshrined in treaty as well as in local legislation almost across the globe, that ensures safeguards and due process insofar as the law of extradition permits it. For example, the authorities are legion that at the committal hearing itself, fair trial principles are not engaged. For example, the right to a fair trial and to a fair hearing doesn't necessarily apply, as it appears in the Guyana Constitution, to a committal hearing, because the constitutional, the preambulatory language of that provision speaks to any person charged with a criminal offense is presumed to be innocent, etc., etc.
Now,
When you look,
Mr. Attorney, isn't that then a valid reason for the applicants to attack the ATP at the source? In other words, they know that the only way extradition process can begin is if ATP is issued. Without issuing an ATP, there will be no extradition process. So if you have an extradition process during which, or in the context of which, the fair trial, all those considerations we take for granted in criminal justice system will not apply, do the applicants then not have an interest in attacking what you call the door to make sure people don't get in to that process where these other rights do not apply? Is that an argument to validate their attack, which one might call a preemptive strike at this stage?
Mr. Nandalal, I don't want to be unfair. I don't know if you could take a note of that, but I really wanted to jump in before that, because I'm not sure I heard you correctly. Are you saying that the Article 144 doesn't apply to committal proceedings? Because if so, that would be an extraordinary submission in my view. And I'd ask you for some authority for that.
Your Honors, if you look, Scantlebury, for example, dealt with it. Scantlebury from Barbados. It's not that it doesn't apply to committal proceedings. In an extradition hearing where there is no charge, because the provision says what it says.
There might be aspects of particular things where certain aspects of Article 144 mightn't apply, but you can't say as a general rule that due process rights, protection of the law rights don't start. Let me finish, please. Yes, don't start from the time of charging. I mean, you couldn't be making that submission, can you?
No, I'm not saying that, but I'm saying that the full impact of the article does not apply, and the authorities say so uniformly. And, Your Honors, I am not saying that the
Mr. Nandalal,
is not reviewable.
Mr. Nandalal, you say, Attorney General, you say something and then you say something else that has caused me pause. When you made that comment, I also made some notes to ask, but my brother has asked. So you say the Constitution is the supreme law, correct?
Of course.
The FOA is legislation in Guyana, correct?
Yes.
Is the legislation subject to the Constitution?
Certainly.
So constitutional principles govern subject to the legislation. and the language. Won't you agree with that?
Yes, Your Honor.
So I'm very troubled when you say, maybe like my brother, I don't know, that, and I wrote it, right to a fair hearing does not apply, and I've highlighted it and put it in bold, to an extradition hearing.
Your
Is
Honor,
that
let me-
what you are suggesting?
No, not at all. Not at all.
No, okay.
Not at all.
And
And
if
the
I'm not,
authorities,
Mr. Nadal, if I'm not mistaken, but don't hold me to this, I think Scantlebury was disapproved by the Guyana Court of Appeal in the paper committals case. But don't hold me to that.
Thank you very much.
Sorry, not to pile on to the the questions you have, Attorney General, but I wonder whether we have to cast our nets so widely. Do you think, because I know you have been generous with your time, and therefore you might want to shorten your run-up to the wicket,
Yes, I'm going to do
given
that
where
right
you're
now.
coming in the
I'm
batting
going to
order,
do
as
that
you
right now.
say.
Justice Usujui point, I am not at all saying that the ATP is not reviewable. In fact, we have conceded that. And where we part company is on what ground it is reviewable. So if I could get back to where I start, and Your Honor, I will abbreviate my run-up. The point is that when we review and examine the ATP function, we must take into account the context. And that is why the authorities say uniformly that certain principles do not apply that would ordinarily apply to other public law functions. They do not apply to the ATP function. It is because of the peculiar nature of the ATP function itself. And that's the fundamental point I want to start with. And the other point I want to make quickly is that, that's the point I've begun by trying to make, is that as a country, Guyana has taken a position since independence in relation to treaty obligations, in relation to international law obligations, and that includes extradition matters. On now to deal with the ATP function.
Yeah, Mr. Nanwa, Attorney General, as you move on to that, we had a lot of submissions. We heard a lot of submissions concerning 12.12.2, and I know you're going there. I wanted to ask you, as you address the court on that, could you let us know what is your role? What is the role of the Attorney General with respect to the exercise of the minister's power under 12.2?
Whereas the Attorney General under Article 112 of the Constitution is the legal advisor to the government of Guyana. And that will include advising the government and ministers and public officers on matters that may come before the Attorney General. In this particular case, two matters came. The Attorney General was engaged in two issues. And I believe Senior Counsel Douglas Mendez dealt with them. One was in relation to what is the position in relation to our treaty and its provisions regarding extradition to a third state. And that issue arose because there was a conflict between a full court decision in Dataram and the DPP and the King and the Director of Prisons. King being a higher court and King having settled the law, and cases subsequent to Dataram having approved King as the authority laying down the correct position. That was the advice that was offered. And in relation to the second issue, it simply had to do with whether the form was filled out properly And all I advise the minister, there's a schedule and there are models or forms in the ministry itself ensure that the precedents are observed. And
So
that's
if
the
I
extent
get you
in
right,
this
then, yes, Honorable Attorney General, if I get you right, then you are not concerned to give the minister any advice on whether the order could not lawfully be made, or would not in fact be made in accordance with the act.
It's not that I'm not concerned to give that advice. Had that advice been requested, perhaps I would have. In this particular case, that was not requested of. Your Honor, it may be of some moment that in this particular case, the Honorable Minister of Home Affairs is a lawyer of nearly 3 decades standing and was a magistrate of Guyana for nearly 8 years. And I put that I believe in her affidavit, and that's the evidence before the court. Whatever moment is made of that is a matter for the court. But Your Honor, the ATP function has been examined by numerous authorities. It was examined by the Court of Appeal in Nogre. Home Secretary, ex parte Nogre. In that case, Your Honor, the Home Secretary was exercising similar powers that the Minister in Guyana was exercising. And there was a request that came to the Home Secretary on a previous occasion. The Home Secretary engaged counsel for the subject, the fugitive offender, and the counsel was able to persuade the Home Secretary against granting the authority to proceed. The counsel wrote to the Home Secretary to say, if another authority comes, please hear us, inform us, and we'll make representation. A second authority to proceed, a second request came, and the Home Secretary issued the authority to proceed without resort to counsel. And the authority to proceed was challenged. It was challenged on the failure of the Home Secretary to grant them a hearing. Now, ordinarily, in ordinary law, I believe respectfully that the ordinary principles of natural justice and legitimate expectation would have been engaged, and ordinarily a hearing entitlement may have arisen. The Court of Appeal rejected that argument and said that the ATP is a gateway function, it is a special function, it is administrative, and it doesn't lend itself to the principles of natural justice.
We follow you there, Mr. Attorney General, very clearly. I would like to go back to the question asked by my sister and your response. You suggested that your advice was sought on the two matters, and you rendered that advice. But, you know, the elephant in the room is that the applicants, stroke appellants, are alleging that the Attorney General made several statements in public which indicated a certain mindset as regards the treatment of any request for the extradition of the appellants. And further, that the Minister of Home Affairs was present at certain events where those statements were made. And I assume the implication is that whether advice was granted formally is of no moment, because the Attorney General had made clear what the position was of his office. How do you respond to that, sir?
Let me add to that, Mr. Attorney, because the president's question is very hugely important. I'm interested in it, and I want to add this to it so you can hopefully address both. In specific terms, the complaint, from what I read, is that the Attorney General cast criminal aspersions against certainly the second applicant. And the Attorney General had a running commentary and an ongoing proceeding, the extradition proceeding, and that the Attorney General basically cast some innuendo on the magistrate hearing the proceedings. Can you please take those into account and advise us of the propriety and fairness of that? I know the Attorney General may be a politician, is a politician, but the AG is a lawyer first.
Thank you very much. Your Honor, it boils down to whether the principles of bias attend to the ATP in this particular context. The case of the applicant is that the bias arises from political rivalry. And we say respectfully that political rivalry and bias in this sense does not apply to the functions of the ATP. Warner, the Privy Council, essentially ruled that, again, natural justice doesn't apply. That is why, Your Honor, we have relied on a number of cases where political dispositions and policy positions were accepted by the court as appropriate factors to influence a decision in a particular way. And we say that those principles apply.
Mr. Nanala, sorry to interrupt you. I'm not sure that you're getting at the question, though, that was asked of you, because you seem to be reducing it to political rivalry. But I think the president's question was directed specifically to statements made by you that actually concerned the extradition specifically, and making statements about what the extradition was, what the outcome should be. And then, as my brother added, statements in relation to how the magistrate was treating the case. So it's not just about political rivalry in the air or generally, but concerning specifically the subject of this case.
Your Honor, I can't recall ever projecting the outcome. What I have said, I've spoken about the extradition proceedings, and I've expressed concerns about the time that it was taking in the magistrate's court. Matters of that nature, matters that are in the public domain that Guyanese generally were speaking about. I don't think that I went anywhere close to expressing a view about a particular outcome. And in relation to the other cases, the other matters, when you examine even the affidavits of the applicants, I was referring to matters, not by myself alone, during the political campaign, which preceded the request. The request was not received as yet, but you had in the public domain the fact that the applicants were the subject of OFAC sanctions. You had the fact that there was a writer's special report published on the 14th of July, 2023, long before their entry into politics, that identified them, and these writers, this is worldwide, identifying the applicants as being investigated by the DEA, the FBI, the Department of Homeland Security, and other U.S. agencies on suspicion of smuggling Colombian cocaine and illegally mined Venezuelan gold to United States, Europe, and the Middle East. The report further states that the applicants were also suspected of laundering money for drug traffickers and criminals, including sanctioned Russian nationals operating in the region. So, the court have to take into account respectfully that there is a political campaign going to, politicians are speaking, they're competing for office. Justice Barrow spoke about the applicants himself admitting him being a fierce critic of the government. You have a politician here who is opposing, and this is his rap sheet. This is what we have to speak about. He was criticizing.
I don't think anybody disputes the fact.
So I just say that, Your Honor, so that we
Mr.
understand
Attorney
the
General,
context.
Honorable Attorney General, if I may, I do not believe anybody disputes the fact that there are indications in the public domain, allegations against the appellant. There's no difficulty, or the appellants. There's no difficulty there at all. I think what we're trying to tease out is whether, given the very high office that you hold, and given your functions that you perform in relation to this matter, you're the chief legal advisor to the government, whether on reflection you think that, I've forgotten the word used by my brother Ibo Osuji, this was a proper or the best way, I should say, to express the government's position. I mean, there is a difference between, I imagine, other ministers, other members of the government making statements, and the Honorable Attorney General, who is the chief legal advisor to the government making statements. And I think we are not, drawing any conclusion or making any findings, but we are just wondering whether the Attorney General making those kinds of statements to which the appellants refer is the best practice for the kind of society and democracy that we seek to encourage in Guyana.
The Attorney General did not make any decision here. The minister made the decision, and the Attorney General advice was limited in its compass, as is the evidence before report. The ministers, and then I wish to dwell a little on the role of the minister.
Yes.
So, Your Honors, first of all, there is some contention that the minister is not named in the legislation, and there is some argument because of that, it can be delegated to any minister. Your Honor, that issue was addressed by our courts in Sobers a very long time ago and settled that the Minister of Home Affairs performs that function, performed it then, performed it since independence, and has been performing that function since.
Mr. Attorney, sorry, sir. I need to return to this. The question is not whether the Attorney General made any decision. The question is the position of the AG in government and in the context of this case. You started your submission by saying the Attorney General is the legal advisor to the government. And in that capacity, the AG advises the government and ministers. And here we are talking about the complaint of the applicants that the AG was making certain comments on the basis of which they are now claiming that the whole process is tainted by bias. And the concern is whether the Attorney General of the country should be making those comments that have been alleged against him in the context of this case, casting aspersions, running a running commentary on an ongoing judicial process, the extradition process, suggesting that by innuendo about the failings or not of the magistrate handling the case. Yes, you say that these are comments in the public domain. Is there something to be said that it is part of the job of the AG to bring the population back to saying, look, respect the process, let the process take its course, rather than making comments that might add to that negative public view on the matter? That's what I'm interested in. I believe, I don't know whether the president goes as far as that, but that's
let me assure you that the Attorney General did not make any improper comments. The comments that were made were in the proper context. They may have been misquoted and used for political purposes, but they were not on improper statements.
Okay.
And they were made in due regard to the administration of justice and the right to form and express opinion.
We hear you, Attorney General. I think we can move on from that point.
Thank you very much, Your Honor. So Your Honors, again, I come back to Warner. In Warner, Warner followed Noglet in holding that the ATP function was special. It was a gateway function. It's purely administrative. And there's a whole body of administrative functions that do not attract the full rigor of natural justice and all the other principles. Not that an administrator performing an administrative function is not required to act fairly. There is always a requirement to act fairly. But there can be situations, and there have been situations, where an administrator can act fairly, but natural justice is not required or employed in the performance of that particular function.
Honorable Attorney General, I think just to nuance what you're saying, I don't know that the natural justice point as a right to be heard is what is being advocated with rigor here. What I think is being argued with greater rigor is the tainting of the process by alleged bias and a debate on which is the relevant test. I thought where you may be going on this is to say that the general Porter and McGill test is not apt, as Mr. Mendez has suggested. It's a different test. But I noticed that you say that the Warner case held that the ATP is purely administrative, but I don't think are you suggesting that administrative actions do not attract the supervisory jurisdiction of the court?
No, not at all, Your Honor. In fact, in our written submissions, in the reply, the applicants seem to think that we have said so. We are not saying so.
So if we agree, right? So if we agree that the decision on the ATP attracts the supervisory jurisdiction of the court, I think we know it's clear that you agree to that. Yes. The question, yes, do we agree to that?
Yes, Your Honor.
Good. So the question becomes, in this case, whether or not a challenge on bias is available. First, conceptually, is a challenge on bias available to the applicants at this stage of an ATP? I raise that because there is a way of reading the Court of Appeal that suggests this may not. So I just want to be clear to understand what is your position. Is it that in your position, in your perspective, a JR challenge on the basis of bias is available at this stage to challenge an ATP?
Generally speaking, yes. If there is any relationship of a pecuniary nature, etc., the ordinary principle, yes.
Okay. What would you say is that test? How do you frame that test? What should be the test? Because I accept the principle way back, the principle of fairness is not one fixed form of fairness, it is contextual. In public law, we understand that. So how would you frame that test?
I respectfully say, Your Honor, that the test must be absent those disqualifying factors. Those disqualifying factors must be absent. And this is a political act, it's an executive act. The authorities have even described it as a diplomatic act. This particular act, once those disqualifying factors are not present, and also one has to look at the policy nature of the decision.
So are those disqualifying acts for you?
It is not reviewable on that ground.
So for you, are the disqualifying acts limited to personal and or proprietary interest? Is that what you are saying? When you see, you use that expression a few times as absent the disqualifying acts. What do you mean specifically by that? Are you limiting that only to some sort of proprietary or personal interest?
Personal, financial, etc.
Limited to that?
Yes, Your Honor.
All right. All right. All right.
And Your Honor, if I may go to...
Sorry. Attorney General,
Yes.
1 second.
Yes.
1 second, please. I'm interested in an exchange you've had with my learned brother, Mr. Justice Jamata, when you say Potter and Maykill is not apt. I'm not sure I see why not. I'm not saying I have a view on it, but I'd like to know why Potter and Maykill test will not apply from at least an adapted version of it, to the extent that we are saying, well, the test for bias has to be seen from the eyes of a reasonable, well-informed person acting in good faith. I'm adding that. In other words, they need to know the circumstances and then ask themselves that in all these circumstances, do we see bias? Isn't there an adaptation of that in this discussion?
I'm not saying that Porter and McGill doesn't apply. I'm saying that Porter and McGill speaks on informed, sensible, prudent bystander who would take into account the particular factual context here. You see, Your Honor's
So the point being, your point being, is your point then being that it does apply to Potter and McGill?
Yes, and we have said so in our written submission.
Okay, sorry, I just wanted to be sure.
And we have detailed, yes, and we have detailed
Attorney General, I don't want to press the point, but my note is the Attorney General's position is that the test in Porter and McGill applies, and you've said so in your written submissions. I may be wrong, but I think that is at odds with what Mr. Mendez has put forward to the first respondent. I think Mr. Mendez has said, and if I'm wrong, Mr. Mendez, please correct me. I think he has said that in this case, the Porter and McGill test is inapt, and in fact, the appropriate test is a different standard test, which is, I'm calling it a public policy test, but it is the test that suggests that all that is required is that the decision maker have an open mind and make a genuine decision. Now, it may sound kind of the same, but there is a significant difference in public law between those two tests. So why am I saying this? Because I want to be very clear on the record that you are of the view that the Porter and McGill test does apply, but when we apply it in this case, there will be no outcome of bias. I just want to be very fair to you about that. That's why I have said what I've said. Is that your position as the Attorney General?
No. If the test applies, bias is not a factor. When one examines all the relevant considerations, a politician can be biased and still act fairly. The test is, did the minister act fairly? Did she follow the statutory conditionality? Was she influenced by something irrelevant? Was she the authorized person to perform
No,
the
no, ma'am.
function?
Yeah, you see, Mr. Attorney, Honorable Attorney General, we have to write a judgment, I assume, at some point in time, and we have to try and understand what the law is before we apply it. So therefore, just to be very clear, you are agreeing, therefore, that from your point of view, the Porter and McGill test does apply, which is a note I made earlier. I just want to be sure. Yes?
It does apply, but once it is applied, then all the factors will be taken into account, and it will conclude with the contention or a possibility of a contention that if a person exercising that power is politically influenced, then that doesn't affect the fairness, the legality of the decision.
The Court of Appeal staged it differently. I think the Court of Appeal came into Porter and McGill as a backup reasoning. Court of Appeal said, to begin with, the test for fairness or bias is not engaged because it is a ministerial function, not judicial. And then say, but in any event,
and that's exactly what.
Even if that argument fails, then Porter and McGill doesn't give you a finding of bias. Is that my understanding of what the Court of Appeal said?
Yes, and we have adopted that position.
All right.
As a very position. So, Your Honor, if it is unclear where we stand, we say that Pinochet disqualification doesn't apply, and even if, and that's the exact manner in which we have expressed it. Your Honor, there's a passage dealing with automatic bias. There's a passage that I want to share with Your Honors. And it's taken from Administrative Law by Sir William Wade, the 10th edition, the 11th edition actually. And they're quoting from Lockerbie, but they have expressed it in a manner that I find very, very interesting, and I would like to share it with the court. And Lockerbie, as the court would know, was decided 1 year after Pinochet. And this is the caption that I want to leave with the court. I sent it along with the authorities. In a leading case, the Court of Appeal, speaking with the special authority, this is the Court of Appeal of England, speaking with the special authority of the Lord Chief Justice, the Master of Rolls, and the Vice Chancellor, be very important and powerful functionaries. Together lay down that while everything will depend upon the facts and nature of the issue to be decided, objections could not be based on religion, ethnic or national origin, gender, age, class, means, or sexual orientation of the judge, nor ordinarily with the judge's educational, social, employment, or service background, nor his political associations, professional associations, example, membership of the inner court, membership of social, sporting, or charitable bodies, or prior decisions, etc. None of these grounds, they are saying, cannot be a basis of objection against a judge. Now, in the judiciary, in the realm of state authorities and powers, the law exacts from the judiciary the highest form of impartiality when performing judicial functions. And they're saying here that the judges' political associations, etc., are to be discounted, are not to be taken into account, or cannot be the basis of challenge. That principle, I dare say, with respect, must apply a fortiori to a politician, a minister, exercising an executive function in a political environment. And that is why we say respectfully, Your Honor, that the ATP doesn't attract the rigor of the bias doctrine as it would ordinarily apply even in administrative tribunals. That is why the legislature vested that power in a minister, and it appears on its face that it is non-delegable. And I advance that proposition as part of my general submissions, moving on to a different issue. And I am happy that the court identifies the difference in the language of the draftsman in section 12, where the legislation devolves a responsibility on the foreign affairs minister, but permits right there upon that devolution, permits a delegation.
Yeah,
But
so,
when it comes to the
Mr. Attorney
minister,
General, thank you very much. I know you're going to go on a little bit further on the delegation issue, but just to draw a line under the question of the test and whether bias is relevant, I do think that the Court of Appeal did make reference to the fact that bias is applicable regardless as to whether the act is described as judicial, quasi-judicial, or administrative. That was clearly said, but of course, the factual context.
That's
factual
correct. That's our
context has to
position,
be
Your Honor,
considered.
respectfully.
Absolutely, and she went on to say, this is the author of the judgment, quoting from Ramdas, that procedural justice obviously applies. And I believe that this was also the view of the Privy Council in the Warner case 2022. So that the point is that procedural justice obviously must dictate the conduct of the minister in deciding whether to grant the ATP. I thought I would just say that because we may not have been quoting exactly verbatim from the Court of Appeal, but the Court of Appeal did in fact suggest that procedural fairness applies in relation to decisions relating to the ATP.
Yeah, and Your Honor, I have said so. That is why I am saying there is always a duty to act fairly.
Yes.
But that doesn't necessarily mean one must engage natural justice to act fairly. In fact, when one reads back CCSU, when Lord Diplock formulated those three heads, irrationality, procedural impropriety, and I believe was illegality. In dealing with procedural impropriety, in explaining why he did not use the term natural justice, is because he conceived of situations where procedural impropriety can be achieved, but the context may not permit the application or doesn't warrant the application of natural justice principles. Lord Ruskin in that very case also said that it's better to let us put the term natural justice to rest and use the term to act fairly instead. And those are the principles, Your Honor, I respectfully ask that we engaged in considering. I'm not at all saying, and the contention, as I understand it, of the applicants is not that they are making an allegation that the minister acted unfairly. They are saying that the minister is infected with the bacteria of bias. In fact, the entire government is infected with that bacteria. And that ipso facto and without more is the germ that is enough to invalidate the decision. And we say respectfully, that is not the law that ought to apply to the ATP function. And that is why I share that passage from Wade, where Wade is saying that even the judges' political association, if they have, ought not to be taken into account. In other words, the Pinochet case has been narrowed significantly in its application. And we have quoted authorities that have narrowed it down too.
I did not mean to provoke you into another flight into this area, Honorable Attorney General. You're going on, I think, to the non-delegable nature of the functions.
Yes, please, if I may resume there with your kind permission.
Yes.
So Your Honor, Where the draftsman wanted the delegation to take place, the draftsman authorized the delegation. Where the draftsman wanted the minister to perform, the power was vested with the minister. And there is a reason. That's why I began the way that I began, by adverting to the nature, the political and international nature of the obligation in relation to extradition. And if I may go quickly to Froome, as reference was made to it repeatedly. Froome says this, speaking about the desirability and the necessity of the minister performing the function. Froome, paragraph 76, says the expertise of the decision maker is the most important factor. They were speaking about the 83. The expertise of the decision maker is the most important factor. The minister has the expertise in political matters, international relations, and the ramifications of the law of extradition. It is the minister who must consider good faith and honor of this country in its relations with other states. This necessitates a high level of deference. So, Your Honor, when Parliament in its wisdom and for great reason, as is exposed here, repose that power in a minister, I say respectfully that we should really be careful and approach it with great circumspection when considering authorizing a delegation. Justice Volcan had asked a question. Oh, sorry.
Mr. Tony, I do not know whether anything writes on this, but let me ask it anyway. The Interpretation and General Clauses Act is Cap 2. The Fugitive Offenders Act is Cap 10. Now, whether or not there's any reasonable rhyme to the enumeration in that way, it's neither here nor there, or maybe it helps. But in drafting Section 12 of the Fugitive Offenders Act, could the Parliament not be presumed to know that the law elsewhere would allow or did provide for Minister of Public functionaries to delegate their functions, and therefore, would that not require for Parliament to have a more explicit in Section 12 in saying only the minister can do this? If I was to, well, without prejudice to any other, law in the country and all that stuff, is that too much to expect of Parliament to know that they would know that the Interpretation Act might have thrown something of a curveball in how we read Section 12?
Your Honor, I'm happy that you have situated the acts in a chronological type of order, because the General Clauses and Interpretation Act predates the Extradition Act by many years.
Yes, okay.
By many years. Therefore, the draftsman, when he drafted the Extradition Act, and he wanted it to be delegated, he delegated it. He knew the provisions of that act, but he still delegated it when he wanted it to be delegated in Section 12. When he wanted it to be kept,
yes,
he kept it.
Shouldn't that sequence of that chronology have influenced or informed the draft person to be clearer in Section 12 in saying minister without prejudice to any other law, minister?
I say, Your Honor, I come back again to the peculiar and sui generis nature of extradition. The extradition, the Fugitive Offenders Act, is a sui generis legislation is considered to be a self-contained code. It has its own appellate process and appellate challenges, etc., at the judicial level. And I ask that it be generally construed that way. And as a self-contained code, the draftsman delegated powers when he wanted to delegate powers, and he did not do so when he did not want to do so. And I want quickly to go to Vroom, and perhaps it will bring greater Vroom. It will bring greater clarity, because Justice Vulcan had asked the question of this amendment. Vroom, the statutory formulation is different. In Vroom, the judge, when examining the statutory landscape, described the ministerial functions at two stages: ante the judicial process and ex post facto the judicial process. Ex post facto the judicial process, that is a surrendering stage. The legislation in Canada used the term personally. The minister shall personally. And because the term personally was used, the court interpreted the ante-judicial stage, that is the ATP stage. It speaks to the minister, but they said because the draftsman used personally at the end, then if it says only minister, the implication is that the minister can delegate. They construed it in a self-contained manner. And I'm inviting this honorable court to apply the same canon of construction, because you have section 6, where there's a delegation, and you have section 12, and there is no delegation. There's another reason, Your Honor, why Parliament wants the minister to perform this function and has made it inalienable. One, it's an executive function. Two, there is an institutional framework that attend the functional obligations of the minister in international law and treaty obligations. There's a repository there of institutional resources available to the minister. And that's why it is the Minister of Home Affairs who has been exercising those and related functions. There's a criminal assistance and mutual assistance platform, international platform, that is located within that ministry. And it is for that reason that Froome says that the expertise of the decision maker is the most important factor. The minister has the expertise in the political matters, in international relations, etc. That is the ministry
Attorney General,
that deals with those functions.
I want to ask something slightly different, but I take your point about the executive function, but in terms of the repository being in the ministry, ministers come and go. And if the repository is in the ministry, a PS, I'm sure, who is more permanent and usually there for several regimes, would have access to the repository. But be that as it may, let's go along with the idea that the minister must make the decision. Are you in alignment with what Mr. Mendez suggested was a proper response to propriety in the system, that if for some reason the extant minister or the involvement of the minister in the process would have contaminated the process, that a proper response under the rule of law would be to take that extradition portfolio and place it in another person. In other words, the recognition that personal bias could contaminate a decision, and the remedy that you remove the person who is implicated and substitute another person. And so that the idea of delegation, in a sense, has been to another. A part of it has been to maybe a non-minister person. But is there a sense in which you can not delegate because you are created either an acting appointment or a temporary appointment, I don't know, but you remove this person who is contaminated out of it while preserving the ministerial function. That's what I understood Mr. Mendes to be suggesting. Do you agree that as a question of law and principle, that is an available and appropriate response?
Your Honor, to whom the contention of the applicants is that the entire executive.
No,
power
I'm
is
not,
tainted.
Mr. Attorney General, I'm not on the facts as yet. I'm on the concept. I'm on the principle. I'm trying to work out for now what would be a theoretical model. It may be on the facts, as you are going to say, no doubt, that this doesn't arise, but I'm just trying to understand what is a theoretical model. Be on delegation. So delegation, as I understand you, it cannot be delegated from ministry. That's what I understand you be saying. So I'm trying to draw a distinction between ministry as repository and a person who happens by the coincidence of presidential appointment to be minister. What is more important, the minister or the person who holds the portfolio, or a person who holds the portfolio and has access to the ministry's, as you put it, repository of experience?
Can you answer in a short shrift, because we have to move on.
If the person is disqualified by law, then another person can be substituted once they remain in the, because that will not be a delegation. That will be a substitution.
Okay.
Very well. Thank you. Mr. Attorney General, you have clawed back all the time that you gave to Mr. Mendes.
Your Honor, can I borrow 10 minutes from Arun Gosai? I don't believe that he will be speaking.
There was no time assigned to Mr. Gosai.
Very well.
So can you wrap up in 5 minutes,
I
please,
just
sir?
wanted to leave with the court one last argument, and it is the policy argument, which I'm sure that Your Honors would have read. It's all in my submissions. That while there is a policy position, the decision maker is entitled to take a position that may be biased towards that policy. And I have articulated and respectfully submitted in my written submissions that there is a policy imperative that is at work here concerning extradition. While there's no duty to extradite, and that it's not mandatory to extradite, once the criteria have been met, then one would expect that the policy would be followed. And that policy was followed in this case. And all the safeguards, all the challenges that the applicants wish to make, they are free to make at the judicial process that will ensue. And there's a whole line of authorities that speak to that. I have here folks on admin law, and if I may respectfully direct Your Honor's attention to the relevant pages, it has to do with where the type of cases, like for example, the policeman who's about to charge. I think Mr. Mendes spoke about that in his written submission. That was one of the analyses given by Gregory Smith, Justice of Appeal in Warner. And there's another one in Wiseman and Borman by Lord Reed, where Lord Reed said that it cannot be that every time a public officer is going to institute charges, that it must offer an accused person a hearing. In Warner case, I believe
Mr. Nandalal, I think I could certainly agree with you with those propositions. But certainly, can we equate a police officer charging with the this procedure under the Fugitive Offenders Act, especially in the context of a section like Section 12? In other words, is there an equivalent obligation on anyone that mirrors Section 12 when you come to charge in the normal criminal sphere?
Your Honor, if I may be briefly with Section 12. And I will after that. Your Honors, we have to be, but I can't tell the court to be careful, obviously the court is careful. Section 12 has to be interpreted with some degree of realism. Now, Section 12 is nothing new to Guyana. Section 12 is not an exceptional provision in Guyana law. In Nogrin, the Home Secretary made an error in interpreting the law when he prepared the ATP. And the court said that nothing is wrong with that. That doesn't invalidate the process. It doesn't render the procedure unfair because there is a judicial process that will deal with the law. Your Honor, if a minister is to perform the function with the complexity and the onerousness that is being urged by the applicants, I dare say, first of all, that minister must be a lawyer. That minister must be a lawyer. And I even went, that minister has to perform a tremendously onerous task. And that is why I have a case here from Trinidad.
My Honorable Attorney General, you have to wrap up 2 minutes. I'm sorry, time has gone.
So Your Honor, that is why they use in the language of the legislation, they say that if the minister is very subjective, and I quoted a case, Your Honor, ex parte Hill, where the language was similar, ex parte Hill. And the minister in that legislation, as many legislation do, they require the equivalent of the local offenses to be stipulated. And the minister got it wrong. As the minister got it wrong in Stokes and Bisham Maraj in Trinidad.
And the court is there to correct the minister if the minister gets it wrong.
Precisely. The court said that we will review that.
Yes.
So the point I am making is that the minister's function doesn't have to be as pure as Caesar's wife. The minister has to perform a function, but that function is not conclusive of the matters. The matters are going to be reviewed at several tiers and stages after by the proper tribunal that shall solely and exclusively and conclusively determine the matters of law.
Thank you.
Thank you very much.
Thank you very much, Attorney General. Sorry for impeding you in mid-flight there, but the time has really gone, and we understand your submissions, and we have your written arguments as well. Mr. Gozai, you're not going to prove me wrong, are you? Do you wish to take the floor?
No, please, Your Honor.
Prove me right. Excellent.
Your Honor, could you indulge me for 10 seconds?
Okay, 10 seconds.
Just simply to say that the references made to what the Honorable Attorney General may or may not have said in relation to the magistrate and the conduct of the extradition proceedings would be irrelevant to any challenge to the ATP, because those statements, whatever they were, would have taken place after the ATP had already been delivered. That's the only point I wish to make.
Thank you. Applicants, appellants, do you have a response to?
Yes, very short. It shall be as short as possible. I'll address the learned friend's comments first. The court is entitled to take into consideration all the matters that occurred before the ATP and the matters that occurred afterwards. And the case on that is Contran, which is in the list of cases which is contained in the supplemental bundle to the reply. That's point number one. So that is incorrect. The second point is that the attorneys representing the appellants, the applicants, raise the issue of the time of 4 hours, which is an important issue in respect of bias. In the reply submissions, reply affidavit filed before the Chief Justice at paragraph 20, and they also raised it in the CCJ application at affidavit pages 81 and 80, paragraph 81 and 80. And that's the affidavit that you have before you. So that matter was specifically pleaded. The third point is the Attorney General not only made statements about extradition before the actual ATP was issued, but he continued to make statements after the ATP was issued, and he continued to make statements while the preliminary inquiry was going on. The third issue, he advised the Attorney General more extensively than is said to the court today, and that the minister, more than was said to the court today, and that is found, first of all, at paragraph 39 of the AG's submissions at first instance, 3940, and it says as follows. Shall I read it for you, Milan? His role was limited to responding to inquiries made by the minister in the course of a statutory function. These inquiries were directed to pure questions of law, including the application of the decisions in King and in Datiram, particularly related to the conflict with the two authorities. The advice proffered, paragraph 40, the advice proffered was that the full court in Datiram was bound by the Court of Appeal decision King, and under the doctrine of stare decisis, had no jurisdictional freedom to depart from it. And the King represents the current law in Guyana. And Article 7 of the treaty embodies the specialty rule. The Attorney General provided his advice in furtherance of his constitutional rule under Section 112 of the Constitution. I make two comments to that. Sections 39 and 40 of the affidavit. I make two comments on that. The first comment is that Section 7 of the treaty prohibits an ATP from being issued.
Article 4 of the treaty.
Article 4 of the treaty, sorry, prevents it from being issued when there are pending charges. Article 4 of the treaty prevents so that advice was wrong, respectfully. So
prejudice could have arisen
in any event. And the second point in respect of that is that an Attorney General who made comments about extradition before the matter began, it was issued, made comments during the course of the preliminary inquiry, gave advice to the magistrate in respect of the ATP, is in my respectful submission, given advice in respect of the decision. It is law that the materiality of the advice is not important, nor is the fact that the participation is enough. So materiality is not important and participation is enough. And
Counsel, sorry. Let me make sure that I understand you. Are you going as too far as to say this on that point? That you have no problem with the substance of the ATP. If the DPP, as you suggest, or any other functionary who is not a minister, had issued the same ATP, you would have no problem. But the problem is that
no non-biased person, Millard.
But I mean, you mentioned the DPP. You mentioned the DPP. You recommended the DPP as a possibility.
Or a permanent secretary or some.
Or a permanent secretary, fair enough. Yeah. So if any of those are issued the same ATP, you would have no difficulty.
But we mean
if there's no bias, and if all the rules are followed and if the law is complied with, we have no problems with that.
Okay.
But it is for the state to do that. So therefore, getting back to this point now, the level of participation is not important. What is important is the participation. And the second thing is the materiality of the participation is not important. Participation is enough. And that can be found in three cases: Delagio, Porter and McGill, and Paris. Right? If I may read this extract from the case.
No, please, if you just gave us the reference, we will read it.
The reference.
The guillotine comes down in 4 minutes at 2 o'clock. Please.
Yeah, the reference is the case of
Delagio.
Delagio, at page 153, subparagraph 9. Subparagraph 9.
What's the test?
No. The other point I wish to make is that the quality of the decision made by the Attorney General is not important. What is important is the qualification. So therefore, all the other matters are of no interest to us at all. Whether she followed or did not follow the advice of the AG, whether she took a decision was rational or proportionate as the case may be. The question is she was not qualified to make that decision because of the fact that the case of Bube says appearances are what matters because bias is often insidious. Bias is often insidious.
With respect, counsel, I think we have heard that point before. Is there any further point in reply you wish to make, arising out of what was said by the other side?
Pre-existing charges. The final point is that we have made it. We have made a point already. Pre-existing charges. The test now is a unitary test, and in respect of
I am not sure I heard anything about pre-existing charges from the other side.
Well, that's mentioned in the affidavit of a little friend.
Yeah, but you're replying to what they have submitted. I don't recall that being said.
All right, okay, very well, my lord.
That we couldn't point to anything reckless or do anything wrong. He said we couldn't point to minister doing anything wrong.
Yes, the question of pointing to the minister doing anything wrong is not, we have not reached there. We are at a pre-minister doing something wrong stage, if I may say so, not doing something wrong stage. We are at the anterior stage, and the anterior stage is the qualification to make the decision because of the location of the minister and the appearance. The important guilt test is about appearances, it's not about what in fact was done. And it's whether a fair and informed observer, lay observers, Justice Balkan said in his recent judgment, a fair man and informed observer, having known all the facts and the appearances are what count.
Very well. I think we have that point very clearly. Thank you very much, Counsel.
There's one point that Prime Minister Ford wants to make, and says he'd be no more than 2 minutes in respect of it. Go ahead.
Well, I think the court will decide whether he goes ahead or not. And right now we have 1 minute. If you want to make a point in 1 minute, Mr. Ford, was that what it was? Yeah.
Thank you, Honors. I will make the point in 1 minute, Your Honor, and I'll divide it accordingly. Your Honor, I just wish to come back to the question in relation to delegation and to make the point that the Interpretation of General Clauses Act applies by the provisions of the very act unless they are specifically excluded. Okay. The other point I want to make, Your Honor, deals with the case of Imperial Oil, which has been cited by Mr. Mendez. The respondent's case in relation to Imperial Oil and the entire test which they have been built upon are cases predicated on the existence of a policy. There's a reference in the Smith Judicial Review of Administrative Action at third edition, pages 222 to 223, in which the court says that the normal standards of adjudication cannot meaningfully be applied to a body entitled to initiate a proposal and then to decide to proceed with it in the face of objections. All the cases cited by the respondents, Your Honors, on this issue deal with situations where the respondents, the minister, the statutory official, is entitled to initiate a proposal. And they are elected on that basis, and then they go into government and they implement policies based on their situation, their peculiar situation. This is a radically different situation from what we have before.
Yes, Mr. Ford, I take the point. In fact, it may not have been you who said it, but it was certainly made earlier. I think we follow that very, very clearly. There's a distinction there. Thank you. I'm going to thank you very much for your submissions, Council, and also Council on the other side as well. May I ask you, and I'm trespassing a lot on your good nature, but could I ask you to just stay in place for about 5 to 10 minutes at the most? We're going to confer and come back to you in about 10 minutes or so. Please stay in place. Thank you very much. Colleagues, could we meet in the breakout room?
Imagine 18 hours of blackout, and you're telling people progress. Cost of living gone up 100%, yet you give public servant less. Mr. President, listen to the people, search your soul and you will confess. I want you try surviving on the public base, then you're gonna know but stress. Cause I done fed up, you done fed up, he done fed up, she done fed up, we done fed up, the people fed up. You're hiding corruption inside the cup, look how evil set up. The people fed up. They don't drive no fear with the citizen. They may want the people speak out. Freedom of speech done gone inside the gutter. Knock off when you open your mouth. Discrimination in entertainment, and you're talking about one Guyana. When the Ministry of Culture keep the big shows, one set to girls and banner. Cause I done fed up, you done fed up, he done fed up, she done fed up, we done fed up, the people fed up. You're hiding corruption inside the cup, look how evil set up. The people fed up. Every picture you take and promise you make, everything you do is about clouds. Then you come into me for I shake your hand, there's nothing to smile about. Corruption inside every sector, but when it comes to them, they send you. Try investigate efficiency, right? Go talk to Baratans too, cause I done fed up, you done fed up, he done fed up, she done fed up, we done fed up, the people fed up. You're hiding corruption inside the cup, look how evil set up. The people fed up. I done fed up on the dirty water, low pressure, want scream and tell somebody. Imagine 1500 US, and they're telling me super salary. I done fed up on the unemployment racism and the lie they say one guy.
PPP will take care of you from erection to resurrection. A quick one for you. And the last time I said that, somebody came up to me and said, man, you little bias. Erection is a man thing. What happened to the women? So I got a woman thing for you. And hear me, from the moment she slime up till you get caught up, we gonna take care of you. Thank you.
Who's that one? Low lights and hungry bellies.
Oh, Jesus Christ, if cost of living double, I don't know what happened. A pound of sugar is $300 already. Flour, everything gone up. Everything just raising. You gotta get about $40,000 for buy good ration. You gotta get 3 man now. A weekend man, a monthly man, and a fortnight man.
I can't take it no more. I can't take it no more. Can't take it no more. Imagine 18 hours of blackout, and and you're telling people progress. Cost of living gone up 100%, yet you give public servant less. Mr. President, listen to the people, so just hold and you will confess. I want you try surviving on the public face, then you're gonna know but stress. Cause I done fed up, you done fed up, he done fed up, she done fed up, we done fed up, the people fed up. You're hiding corruption inside the cup, look how evil set up. The people fed up. They don't drive no fair with the citizen. They may want the people speak out. Freedom of speech done gone inside the gutter. Knock off when you open your mouth. Discrimination in entertainment, and you're talking about one Guyana. When the Ministry of Culture keep the big shows, one set of girls and banner. Cause I done fed up, you done fed up, he done fed up, she done fed up, we done fed up, the people fed up. You're hiding corruption inside the cup, look how evil set up. The people fed up. Every picture you take and promise you make, everything you do is about clouds. Then you come into me for I shake your hand, there's nothing to smile about. Corruption inside every sector, but when it comes to them, they send you. Try investigate efficiency, right? Go talk to Barretons too, cause I done fed up, you done fed up, he done fed up, she done fed up, we done fed up, the people fed up. You're hiding corruption inside the cup, look how evil set up.
Thank you very much. Well, once again, the court thanks counsel for their diligence, efficiency, and the support you have given us in considering this matter. We are not yet in a position to give a decision on the application before us. Therefore, we are going to reserve until such time as we are so able. Now, the court is, of course, sensitive and aware of the fact that we are dealing with extradition matters, and these should be handled with expedition. But obviously, equally, we want to give due care and consideration to the arguments that have been put before us, and to ensure that the application is given due consideration. So we will have our decision as soon as is reasonably practical, given what I have just said. Two further things to mention. The first is just to emphasize that the interim stay of proceedings will obviously continue until the decision is made by this court on the application. And the second thing I'd like to say is that, of course, this court does not seek to regulate public commentary on judicial matters. We are well aware that counsel has a right to free speech, and we encourage the exercise thereof, of course. However, statements which are made outside of these proceedings and which could have the effect of undermining the fairness of the proceedings, or which could undermine public confidence in the administration of justice, should be avoided. And we would expect counsel on both sides to adhere to their professional responsibilities as far as that is concerned. We hope that that issue does not arise for any further comment by this court, but I am pretty sure counsel understands the need for proper behavior in this regard. And I say counsel, of course, on all sides. Well, thank you very much. Is there anything from counsel on this? Or any other matter?
Thank you very much.
You are most welcome, sir. Welcome. First respondent.
Nothing further from us. Thank you very much, Your Honors.
Thank you very much. Second respondent.
Nothing further, please, Your Honor. Thank you very much.
Thank you, sir. And third respondent.
Nothing from the third respondent, please, Your Honor.
Thank you, sir. Thank you very much. Thank you all, and we'll be in touch as soon as is reasonably possible. Madam Deputy Registrar, would you please close these proceedings?
Certainly. Thank you, President. Thank you, Madam Justice Rajnakli. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Jamada. Thank you, Madam Justice Ononu. Thank you, Mr. Justice Ebosuji. And thank you, Mr. Justice Balkan. Thank you, Counsel. And did I say Justice Jamada? If I did not, thank you, Justice Jamada. Thank you, Counsel, and thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you very much.
I can't take it no more.